Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. This morning, the Judiciary Committee will resume consideration of H.R. 2431, the Davis-Oliver Act. When we ended last week's markup of this bill, we were in the process of considering amendments. Are there further amendments to H.R. 2431? For purpose, the gentleman from New York seek recognition.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R.
The point of order has been reserved. Clerk will report the amendment.
Amendment to H.R. 2431 offered by Mr. Nadler. Strike Section 310 and redesignate provisions and conform the table of
Without
contents.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment would strike Section 310, an unconstitutional provision that authorizes and in some cases mandates the indefinite and possibly permanent detention of certain immigrants with virtually no procedural protections for those who are detained. Section 310 is presumably intended to address the Supreme Court's decision in Zadvidas versus Davis. That case concerned instances in which a detained individual is ordered removed from the country, but the government is not able to carry out the removal in a reasonable period of time. This may occur because a country refuses to accept the return of its own nationals, or no country even recognizes the detainee as a citizen or a national, perhaps after a regime change or shifting borders in the land of origin. In such circumstances, the Supreme Court held that after a reasonable period of time, generally thought to be 6 months, if removal is not reasonably foreseeable, the immigrant must be released from detention, except in certain exceptional circumstances. Importantly, the court held that indefinite detention of such immigrants would raise serious constitutional concerns. It found that preventive detention of non-citizens who are unable to be removed is justified only when an individual is found to be especially dangerous and when there are strong procedural protections accompanying any such determination. This bill, however, falls dangerously short of the Supreme Court's stringent requirements. Under this bill, where removal is not feasible, the Secretary of Homeland Discretion may, in the Secretary's sole discretion, detain certain undocumented immigrants indefinitely, with no hearing and no meaningful due process. If the person was ordered removed due to criminal convictions, even for nonviolent crimes such as theft or drug possession, detention is mandatory until they are successfully removed, with little ability for the detainee to challenge his detention. And that detention may be indefinite if the removal cannot be effectuated. The bill provides for no individualized determination that a person is especially dangerous and provides hardly any procedural protections whatsoever. The Supreme Court contemplated indefinite detention in only narrow circumstances, but this bill flatly ignores the strict standards set by the court governing such rare cases. Indefinite detention is contrary to American principles of due process, and it is repugnant to our values of fairness and individual liberty. The rationale behind this provision, as with most provisions in the underlying bill, appears to be that undocumented immigrants are presumed to be dangerous and that they are not entitled to the fundamental protections we guarantee to all who are present in this country. Under current law, it is already possible for individuals who cannot be removed to be detained for prolonged periods of time, even indefinitely, but only if there is a determination, subject to proper procedural safeguards, that they are especially dangerous or that they pose national security risks. This bill, however, would subject broad categories of offenders, even those who present no danger to their communities, to indefinite detention based on the thinnest of procedures. This amendment would preserve the status quo, which strikes a better balance between respecting individual liberty and protecting public safety. This amendment would also remove the discrepancy between this provision and the clear ruling of the Supreme Court of the United States. I urge my colleagues to support the amendment, and I yield back the balance of my time.
What purpose does the gentleman from Idaho seek recognition?
Mr. Chairman, I oppose the amendment.
Gentleman is recognized for 5 minutes.
In 2008, the 10th Circuit provided a solid basis for the constitutionality of Davis-Oliver's detention provisions, allowing DHS to continue to detain dangerous aliens who cannot be removed. In Hernandez-Carrera versus Carlson, the 10th Circuit post-Savidas upheld a Department of Justice regulation that closely mirrors the provisions in the bill. The 10th Circuit stated that, quote, in Zavidas, the government argued that the Immigration and Nationality Act did not place a limit on the length of time beyond the removal period that an alien may be detained. Far from limiting the Attorney General's detention authority to a small segment of particularly dangerous individuals, this reading would have authorized the detention of any removable alien without regard to any alien's dangerousness or special characteristics. As the Supreme Court pointed out, this construction suggests at its limit that Congress had authorized the Attorney General to permanently detain an alien guilty only of a tourist visa violation.
Left, certainly.
Close quote. Bearing the court's guidance in Zavidas in mind, the Attorney General not interprets the INA to authorize detention beyond its removal period only in limited special circumstances. Detention beyond the removal period is authorized only in situations where the government's interest in an alien's continued detention is particularly strong. In cases of 1, aliens with a highly contagious disease that is a threat to public safety; 2, aliens detained on account of serious adverse foreign policy consequences of release; 3, aliens detained on account of security or terrorism concerns; and 4, aliens determined to pose a special danger to the public. Therefore, in contrast to the expansive scope of ICE's detention authority advanced by the government in Zavidas, the Attorney General has now interpreted the INA only to authorize continued detention for a small segment of individuals whose release would particularly endanger the public's health or safety or the nation's foreign relations. We are confident that due process is satisfied here. The Attorney General's interpretation of the INA allows Congress to have authorized the detention of limited classes of aliens, including those who are particularly dangerous, mentally ill, and cannot be released without jeopardizing the public's safety, so that they need not be released into the general population only because no other country will accept them. This interpretation, according to the 10th Circuit, is eminently reasonable. The detention of dangerous alien provision in this bill conforms closely to the regulations upheld by the 10th Circuit, and therefore this provision is constitutional, and I urge all my colleagues to reject this.
Will the gentleman yield for a question?
Yes?
So I'm just, having just listened to Mr. Nadler and now listening to your argument, I'm just reading, and I'd love to know your thoughts on this. I'm reading from Zavidas versus Davis, a United States Supreme Court decision, and in that the court said that a statute permitting indefinite detention of a non-citizen, and I quote, would raise a serious constitutional problem. They go on to caution, in cases in which preventive detention is of potentially indefinite duration, we have also demanded that the dangerousness rationale be accompanied by some other special circumstance, such as mental illness, that helps to create the danger, and went on to say it must also be accompanied by robust procedural protections. So my question is, the Supreme Court of the United States said a statute that provides for indefinite detention, which this provision does, would raise serious constitutional concerns, then go on to say, but it must require a special finding of dangerousness, some special circumstance such as mental illness, or that helps to create the danger, which I don't think your statute does. And then finally it says it must be accompanied by robust procedural protections, which don't exist. So it seems as if Zavidas versus Davis would make your proposed language clearly unconstitutional.
Well, clearly the 10th Circuit addressed your issue.
Well, this is the United States Supreme Court.
But the 10th Circuit already addressed your issues post-Zavidas, and they were not overturned by the Supreme Court, so your interpretation is incorrect. And I yield back my...
Well, would the gentleman yield?
Would the gentleman yield?
Yes.
Or I'm sorry, to the chairman, I guess.
I thank the gentleman for yielding. I just want to point out that the Supreme Court's language is dicta. It is not the law. And since the 10th Circuit's ruling, as the gentleman from Idaho noted, occurred after the language in Zavidas that you cite took place.
Mr. Chairman, will you answer the question?
Then it is appropriate to follow the 10th Circuit opinion as the Obama administration did And now we're simply codifying that. So, in my opinion, this is a perfectly legitimate approach to how to deal with the unfortunate circumstance that some countries don't cooperate with us in return of citizens. I also note that the new State Department leadership and the new Justice Department leadership are working hard to make sure that the laws are enforced with regard to admissions of people from those countries who refuse to take their citizens back. And this is a part of the formula of getting that done. I thank the gentleman for yielding.
Mr. Chairman?
Would the gentleman further yield, or would I move to strike the last word? I'll be
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And I just want to codify some questions here, and perhaps the gentleman from Idaho can answer them. If I understand correctly, the vast majority of people that we're talking about under this law, proposed law, would be people who, in the ordinary course, if they chose to go back, their country would take them back. If they had no crimes committed, their country would take them back. Their country continues to send people here, but in most cases, because they object to going back and they know that their country will refuse to take them back, they're gaming the system to get released. In other words, the past Supreme Court decisions have created an opportunity for people to game the system to get released when, in fact, if the day after they're released, they decided to go visit their relatives in that country, they'd be allowed to. Is that correct?
That is correct.
So what we're really trying to do is create a tool so that the State Department can validly work with these countries to ensure that the ordinary country-to-country relationship, which includes taking your less desirable citizens back, would be upheld. Is that correct?
That is correct.
Well, then I am all for it as it is, and certainly would not want to limit the ability to deport undesirables, especially to countries that they have no fear other than they'd rather stay here even after they've committed crimes. And I thank the gentleman, and I yield back.
What person, the gentlewoman from California, seek recognition?
To strike the last word.
Gentlewoman is recognized for 5 minutes.
I think that the reliance on a circuit court as opposed to the Supreme Court is probably a mistake. There are other constitutional problems in this bill, but I don't think that is deterring the majority from going ahead to enact an unconstitutional statute. But putting that to one side, I do think that working within the Zedaius decision, there are refinements that could be made. I think we're all aware that there have been occasional instances where people who posed a threat were, because of the Supreme Court decision, released. And the court has given us an opportunity to legislate an answer to those limited circumstances that provides for robust administrative review, which is absent in this. A habeas petition is not going to cut it in terms of robust administrative review. A definition and of why a person is deemed dangerous, which I think is deficient in the bill. So I think, Mr. Nadler's amendment is absolutely correct, but we also, because of the bill, are missing an opportunity to actually do something substantial in an area of the law where it would be wise for us to work together to do something substantial. The other thing I wanted to mention is there are a number of people who are held in the United States who are stateless. They were born someplace, but they're not recognized as citizens of the place where they are born, and they can't be removed because they're not a citizen of any place. The court has made clear that absent other factors, that person cannot be held for the rest of their life in immigration detention. There's got to be some process to deal with those situations. And finally, we had talked earlier and in various hearings about the need to put pressure on some countries that refuse to accept their citizens who have committed offenses that are serious. The biggest offender was Cuba in terms of numbers, And I don't know that we've done anything so far really to put the hammer down on the Cuban government to accept back their nationals who have committed serious offenses. We've made progress with Cambodia and certain other countries, other areas, nothing. And so there, excuse me, I do think that addressing that issue, which is not present here, would be wise, and I yield back.
For purposes, the gentleman from Florida seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes, sir.
Thank you, Mr. Chairman, and I am incredibly proud of the work that this committee has done and that the House has done to combat sexual violence. And I believe that this amendment undermines that great work and that we need to preserve Section 310 of the Labrador Bill to ensure that we don't inadvertently create a system that is more conducive to sexual violence. I absolutely agree with the comments that Ms. Lofgren made, that Cuba is a particular offender of this system whereby they do not take back some of their violent sexual predators when we ask. And the gentlelady is correct that the administration, no matter who it is, should put pressure on countries to take back the people who commit heinous crimes in our country. The problem is that the Obama administration did just the opposite. Rather than bringing pressure to bear on Cuba to take back terrible people who had done terrible things, we instead cozied up to Cuba with no conditions, with no protections for our streets. I think it's noteworthy that the Boston Globe, not exactly a place that's a bastion of conservative thought, the Boston Globe did a study on some of the downstream effects of the Zedaitis decision in the space of violent sexual crimes. They found that convicted rapists, child molesters, and kidnappers were released as a consequence of this decision without the requirement that they register with state or local authorities as the law requires. There are a few of these examples that are particularly instructive. Luis Leyva Vargas, age 47, had unlawful sex with a teen. He was released in 2008 as a consequence of the Obama administration's interpretation of the Zedaitis decision. And then 2 years later, he kidnapped an 18-year-old girl in Virginia and raped her at knife point. Felix Rodriguez, 67 years old, a sex offender convicted of raping children as young as the age of 4 in the 90s, was freed, also because Cuba would not take him back. Months later, he fatally shot his girlfriend in Kansas City. Andrew Stanley, convicted in 2000 of sodomizing a child, was released in 2009 after Brazil failed to provide him the passport that would be needed to send him home. For the next 2 years, he viciously abused 3 children in St. Louis, and now at the age of 31 will be in prison for the rest of his life. So time and again, we see circumstances where the Obama administration's interpretation of these decisions has resulted in the inability to have the tools at our disposal to stop sexual violence and to hold people accountable for that violence. So I'm going to support the Labrador bill. I'm going to oppose Mr. Nadler's amendment because I don't want to be in an environment where our law enforcement, where our ICE agents, where folks who are administering our laws at every level of government are not able to hold people long enough so that the Trump administration can now exert appropriate pressure on home countries to take back the very people that do the harm that we are fighting so hard in a bipartisan manner to stop in this committee.
Would the gentleman yield for just a...
I will.
I just wanted to comment on the Cuba issue because I was critical, and I still am, but the Obama administration did start discussions. Cuba has now taken really just a handful of criminals back. Much more needs to be done, but I think I left the impression that nothing had been done under the Obama administration, which was factually incorrect, and I thank the gentleman for allowing me to correct my misstatement.
Certainly,
I
yield
move
back.
to strike the last word, Mr. Chairman.
The gentleman from Illinois is recognized for 5 minutes.
Thank you, Mr. Chairman. Well, first of all, I couldn't agree more that dangerous people should be subject to severe sanctions. But what does someone shoplifting at a local store have to do with being dangerous? Should someone who, picks up a ring, something at a jewelry store, some cosmetic, I don't think anybody here would say they're dangerous. They're petty thieves, but not dangerous. I can think of a lot of white-collar crimes. I can think of a lot of crimes in which people aren't considered dangerous. But the examples that are given to us is that we're going to take people who did very little. I mean, I could think of a former congressman. He was just here in the last Congress. He was caught by the DEA using cocaine. And after several weeks, he decided he was going to resign. But what happened to that congressman? Let me think. Because it wasn't a violent crime, he was given a suspended sentence, and for a year he went to get drug therapy so that he wouldn't do it again. So there is the way the law is implemented. But what you're doing here is you're saying that everyone, regardless of what crime they committed or what violation of the law they committed, should be able to, we should be able to have them spend the rest of their lives in jail. And I want to just go back to something that Mr. Nadler and that Congressman Solofrin mentioned. And that is that it doesn't, I think my friend Cicilline also mentioned it, it doesn't resolve the problem. By doing this, it isn't as though all of the countries are going to say, oh, this is such a terrible thing, let's just take them all back. So it doesn't resolve the issue, because it seems to me that the underwriting issue on the part of the majority is that by doing this, they're somehow going to take people back. So it doesn't solve the problem that you've put forward. And I do want to say that the majority likes to tell us in the minority, oh, well, Obama did it. Well, let me just make it very clear to the majority that unlike the majority who can find nothing that President Trump does wrong, the minority found on numerous occasions things and challenged President Obama because of his policies, both on immigration and in other aspects of the law. So the minority sees ourselves as the legislative branch of government that is a check and a balance against the executive branch of government. And we have fundamentally do that. So I would hope the majority would stop talking about what Obama did, since not all of us on this side agree with everything Obama did. Lastly, I want to go to the question of Cuba, because they made a big deal about Cuba. It was the majority's position for years that any Cuban that set foot in the United States of America was automatically granted asylum in the United States of America. That was your position. And when the Marielitos came by the tens of thousands to this country, Fidel Castro just said to the jail cells, just let all of the criminals come, along with many other people. Y'all didn't do anything about it. You didn't change the policy. You didn't say, oh my God, look what Fidel's doing. He's sending all these criminals here, let's stop them. No, you put politics and ideology ahead, which is what you usually do. So please, don't come and put on us that there are Cubans in the United States of America that Cuba won't take back, when it was your policy that said to anybody in Cuba, touch the land of the United States, and wait a minute, we're going to give you food stamps, we're going to give you a Section 8 certificate, we're going to give you a nice cash bonus as soon as you get here. We're going to treat you like royalty when you get to the United States of America. And guess what? Within a couple of years, you can become a citizen of the United States of America. And even though the majority saw those people who received refugee status in the United States of America, you saw them returning to Cuba, the very country that they fled, that said that they needed to flee, that their life was in danger, that we gave them refugee status. What did they do after we gave them asylum? They went back to Cuba and visited their relatives from the very country that they fled. So please, don't put it on us. I think you also have some soul-searching to look.
Time of the gentleman has expired. For purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I strongly support Mr. Nadler's amendment. Any time that you create a circumstance in which there is no discretion, the potential for abuse and injustice is pervasive. I think everyone on this committee understands our responsibility to ensure that dangerous criminals are not only deported, but are kept in detention if they pose a danger to the community. Everyone agrees with that. There is nothing in current law that prevents that from happening. In fact, it happens every single day. Individuals are detained when a determination is made that they are dangerous, they've committed a crime, and they can't be released into the community without undermining public safety. It happens every single day. But what this new language would do is make mandatory the detention of individuals who have been convicted of a crime, including nonviolent crimes such as theft or drug possession or bouncing a check. And we just added to that category of convictions just being in the United States. This statute criminalizes that as well. And so you have the potential for individuals who may not be welcomed back by their country of origin being detained indefinitely for the rest of their lives for minor offenses. That undermines the basic principles of our Constitution that before you can deprive individuals of their liberty, there must be due process of law, and the notion that we would find it acceptable to keep someone in prison for the rest of their life, 30 or 40 or 50 years, because they bounced a check or mowed someone's lawn and got paid cash under the table, I think is contrary to our Constitution and certainly contrary to, I think, what most people would think is decent and appropriate behavior. The Supreme Court of the United States has warned us that unlimited detention of individuals without strong procedural protections, unless there's a finding that that person is especially dangerous, a specific finding raises serious constitutional concerns. And we have always in the law required that there be a finding, that there be a dangerous rationale, that there be a finding of dangerousness accompanied by some special circumstance that that person poses a danger to the community before you can detain someone for an unlimited period of time. Think about what that means, to detain someone for the rest of their natural life. The real answer to this, as the gentlelady from California mentioned, this is an issue which we should be prepared to work with each other in a bipartisan way. The Departments of State and Homeland Security are working cooperatively under a memorandum of understanding to exert sanctions over countries that refuse to accept individuals from their countries, and that's producing some good results. That's what we should be doing to address the problem of countries who refuse to accept people back. But the idea that we would consider an appropriate remedy to keep someone in detention indefinitely for relatively minor offenses and the absence of strong procedural protections is not who we are as a country. It unfairly paints people who may be in America without proper documentation as criminals. I will say once again that immigrants to our country have strengthened America, have made us a more prosperous country, have made significant, enormous contributions to America, and the idea that we would move forward on a bill and a section in particular that paints with a very broad brush everyone with an expanded view of what crimes are subject to removal, I think is a dangerous practice, undermines our Constitution, violates the kind of founding principles of our country, and I strongly support Mr. Nadler's amendment. And with
For purpose of the gentleman from Texas.
Mr. Chairman,
Gentleman from Texas.
can I withdraw my point of order?
Gentleman's point of order is withdrawn. The gentleman from Texas, for what purpose do you seek recognition?
Strike the last word.
Gentleman's recognized for 5 minutes.
We had a hearing on the crime subcommittee, I believe, and the director of the Bureau of Prisons said that in the federal penitentiary alone, not state prisons or local jails, there were over 20,000 foreign nationals in federal prisons. I think his number was 23,000. If the system works correctly, after those people are in prison, and while they're in prison, they're ordered deported, and then when they get out of prison, they're sent straight back where they came from. The problem is, as Ms. Lofgren and I have worked on, many countries just don't take them back. They have enough criminals of their own. They don't want any more coming back over to where they originally came from. Cuba's the #1 offender. China is the #2 offenders. But there are many countries, and for the record, I'd like to have unanimous consent to introduce the, I guess it'd be the top 25 countries that don't take their foreign nationals back.
Without objection will be made a part of the record.
In 2015, my understanding was, or is, that there were over 35,000 Chinese prisoners in American prisons waiting final order to be deported. There are no consequences for China and Cuba, Vietnam, Pakistan, and all of the other countries that don't take their lawfully deported citizens back. So many of them just are released after they do 6 more months in the detention. And we've all heard the stories about those foreign nationals who have been in prison, ordered deported, released, and commit another crime as well. There has to be a consequence for these countries that refuse to take back lawfully deported citizens of that country. One of those should be that the country should lose diplomatic visas, lawful visas, to come into the United States. Part of that philosophy is in this bill. I think we should go further than that and prevent other visas, such as student visas, from those countries. Then those countries will start taking back their lawfully deported individuals.
The gentleman yield?
Who's asking that question? Yes, sir.
Thank you. I thank the gentleman for yielding. I would just point out that what the gentleman is talking about may be desirable policy, but has nothing to do with this amendment. This amendment deals with the question not of how you deal with the foreign government, but of what you do with someone here who can't be deported to that foreign government. And the question is, can you hold that person indefinitely with a minimum of due process? And the amendment contends, I contend, that you cannot, because it runs afoul of the Supreme Court decision, and you shouldn't. There's got to be some sort of reasonable due process to hold someone in detention indefinitely, and that's what this amendment is about.
I reclaim my time.
Thank you.
I thank the gentleman. You know, I'm from Texas, so I'm a little slow getting to the point. So if we work on that end, this problem of indefinite detention hopefully can be solved if there's a consequence for countries not taking their lawfully deported individuals back, and then they'll take them back, and they won't be in custody indefinitely. That's what I think we should work on as well. If I understand the correct rulings of the court, the Supreme Court has ruled, as the chairman has said, in dicta, that there should be some type of remedy for people that are indefinitely detained. The 10th Circuit case is after that, and there was no appeal of the 10th Circuit case to the Supreme Court. So there's not a case in controversy before the Supreme Court, and the 10th Circuit case then is the law of the land. I personally have a concern about indefinite detention of individuals. I just have an overall concern about that. But I think the 10th Circuit case is the law of the land, and unless Congress wants to remedy that and change it, as Mr. Nadler wants to do in his amendment, then it's going to stay the law of the land. My point being to the chairman is we have to work on the reason why these people are being detained for such a long period of time, remembering that over 20% of the people in federal penitentiaries come from some other place other than the United States. I'll yield back to the chair.
For purposes, the gentlewoman from Texas seek recognition.
Strike the last word.
The gentlewoman's recognized for 5 minutes.
Well, my good friend from Texas has offered a thoughtful perspective. But I think the point that I want to make is that this underlying bill is exceedingly harsh. It really has no purpose in its harshness. It's punitive. It is intending to take a sledgehammer. Now, mixing apples and oranges of labeling all non-status individuals as criminals. That's the underlying premise. You're 6 years old and unstatus, you're a criminal. And therefore, it has little legitimacy for any of us who want a thoughtful perspective to immigration reform. I've introduced legislation for more than a decade on the issue of immigration reform. The Gang of Eight a couple of years ago, till people got weak-kneed, had at least a proposal that passed the Senate. It even had some support but opposition over here in the House, but we were prepared to begin to address the question. We didn't do it. Now, crossings on the border are down. People are not coming across the border. Tourists are not coming to the United States because of the ugly face of how we treat immigrants. And all that we're dealing with are individuals who are here unstatus, who are families and children, totaling the number keeps going from one number to the next, about 11 million, who are going further and further and further under the shade, going deeply out of society, frightened for their life, afraid of the deportation task force that General Sessions and the President of the United States happily have proposed and funded in this heinous, cruel budget that we will be addressing tomorrow. And so I support Mr. Nadler's amendment. Bar the 10th Circuit, the Supreme Court has made it very clear that one of the core tenets of democracy enshrined in our Constitution is the protection of the individual liberty of every person within the United States, a liberty that cannot be violated without due process of law. And our Constitution requires that every person get their day in court. No one can be disappeared and banished in a gulag, similar to what happens in Russia and to other governments of that type, in Turkey, where individuals are never seen. We typically don't have the government bashing protesters as the president of Turkey did. We're in a democracy, and all on our soil are owed that respect, which, by the way, is the respect I want to offer to the President of the United States. This committee has done nothing to begin an impeachment inquiry so that we can follow the facts. Done nothing. And in light of the most recent appalling announcements of the National Security Agency Director and the National Intelligence Director asking to, in essence, cover up whether there's Russian collusion, I still want democracy and due process for the highest office in the land. That's what I expect Director Mueller is going to do. Follow the facts, but do it in a way that each person has their due process rights. There are crimes being performed right in front of the eyes of the American people. Nobody on this committee is interested on the other side of the aisle. Nobody wants to hold the appropriate fact-finding hearings with Sally Yates, former Director Comey. Here we are again talking about a bill that undermines the Constitution and goes against a Supreme Court decision. So all I can say to my colleagues, thank goodness for Jerry Nadler's amendment. And he recognizes that this committee still has a responsibility for the Constitution. And I would rise to support it, but I still raise the question as I conclude, are we going to do anything regarding what is in front of us as a Judiciary Committee that upholds the Constitution and begins to explore the facts that are occurring and swirling around the Oval Office? I support the Nadler amendment. I yield back.
Question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. Roll call vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? No. Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? No. Mr. Johnson votes no. Mr. Biggs? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
Gentleman from Colorado. Have you voted already? Has every member voted who wishes to vote? The gentleman from California, Mr. Issa. Gentleman from California, Mr. Issa.
Mr. Issa votes no.
Gentleman from Tennessee, Mr. Cohen.
Mr. Cohen votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 11 members voted aye, 17 members voted no.
And the amendment is not agreed to. Are there further amendments for purpose the gentleman from California seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Oh, here it comes.
Starting with the next amendment, if the amendment is not at the desk when it's called for, then we're going to move on to another member's amendment that is at the desk, because I see that some are there ready to be considered.
Amendment to H.R. 2431, offered by Ms. Lofgren. Strike
Without
section.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. Law enforcement leaders around the country oppose this bill because it would force states and localities to enforce federal immigration laws, which harms community policing and thereby jeopardizes public safety. Defenders of this bill say it merely gives state and local law enforcement the option to enforce immigration laws if they want to use that authority. Section 114, which this amendment would strike, provides that any state or locality that adopts a statute, policy, or practice that puts public safety and community policing ahead of immigration enforcement is barred from receiving various forms of federal funding, including Cops on the Beat funds to support community policing efforts, as well as burn JAG grants that provide funding for law enforcement, and other DOJ or DHS grants related to law enforcement, terrorism, national security, or immigration. Now, the Major Cities Police Chiefs Association, which represents police departments from all major metropolitan areas of the country, has opposed this bill because it will make their jobs harder. This is what they said. We respectfully ask that Congress leave to local government the decisions related to how local law enforcement agencies allocate their resources, direct their workforce, and define the duties of their employees. The role of local police officers relating to immigration enforcement should be left to local government. Surely it is not good public policy to force an unwanted role upon police through the threat of sanctions or withholding police assistance funding. In a recent op-ed in Roll Call, the police chief of Dayton, Ohio, specifically wrote that these types of policies would be an unmitigated disaster and would actually make communities less safe. Now, speaking in opposition of this bill in the 113th Congress, the police chief of Riverside, California, said that when law enforcement officers are perceived to be an arm of immigration, there are people in the immigrant community who would avoid contact with the police and anybody else in the criminal justice system. They don't report crimes, they don't identify criminals, they don't give testimony to the police, nor do they do so in court. This is an advantage only for criminals. I think it is perverse, as this bill would do, to punish communities that prioritize public safety through community policing to deny cops on the beat and burn JAG funds. The cops funding is intended to promote community policing, and it would be denied institutions and local governments who are in fact prioritizing community policing. The Burn JAG program is a top source of federal justice funding provided to state and localities. In 2016, JAG funding was a total of $274.9 million to states, tribes, and local governments, and it's really important funding for the arrest and prosecution and corrections relative to drug enforcement and crime and victim witness initiatives. So I just don't think it makes sense to deny these funds to local governments that are prioritizing public safety. The Department of Homeland Security funds also are important, relating to biological, radiological, nuclear, cyber attacks. Denying such grants really is unwise, and I think this amendment would solve that problem. I yield back.
Propose the gentleman from Idaho seek recognition.
Mr. Chairman, I oppose this amendment.
Gentleman is recognized.
This amendment is predicated on the argument that Section 114 unconstitutionally commandeers states and localities. This is simply incorrect. In the Supreme Court's 1997 decision in Prince versus United States, the court held that the government could not compel state and local law enforcement to conduct background checks for all guns transfers. More broadly, the court found that the federal government could not impose an affirmative duty or regulatory scheme on states which would necessitate the state taking time to carry out such a duty. Under the 10th Amendment, there are two spheres, a federal sphere and a state sphere. The Davis-Oliver Act neither requires states and localities to adopt a regulatory scheme nor imposes any affirmative duty on them. Those states and localities that proactively wish to direct their law enforcement officers to assist in federal immigration enforcement may do so. This is purely voluntary and not an impermissible extension of federal authority. Section 114 simply amends and clarifies that two-decade-old provision in the Immigration and Nationality Act to ensure that states and localities cannot prohibit their officers from voluntarily communicating with ICE and providing assistance. And I want to repeat that. Nothing in this bill is requiring the states to do something. We're trying to ensure that the states and localities do not prohibit the local officers from assisting immigration. No affirmative duty exists here. The federal government is not forcing states or localities to divert time or resources away from matters within their own sphere. Simply, this provision prohibits them from interfering in their officers' decisions to help keep our nation safe. It's astounding to me that for the last 2 weeks, we have heard argument after argument after argument trying to protect criminal aliens as opposed to trying to protect the citizens of the United States. Sanctuary policies do not serve a legitimate purpose and seek only to impede the lawful enforcement of federal immigration laws. Recent data suggests that in the past year, arrests by ICE have increased tremendously in cities without these policies, while they have stayed stagnant or decreased in jurisdictions with sanctuary practices. Can we assume that there are no criminal aliens in cities such as San Francisco? No, these numbers reflect a true lack of cooperation which will do nothing but ultimately threaten the citizens of those communities. Furthermore, any requirements for the provision of information would not rise to the level of commandeering. This requirement does not impose a targeted affirmative coercive duty on states or localities. The information being requested is readily available and will not cost states or localities undue time or money in order to provide such information to the federal government. Additionally, as the federal government will reimburse states and localities for the cost of providing this information, it would not pass muster as commandeering under Prince. It is not commandeering for the federal government to prohibit policies and practices that handcuff state and local law enforcement officers. It is likewise not commandeering to request biographic and identifying information from states or localities. I urge my colleagues to oppose this amendment. And I yield back.
Mr. Chairman.
Question for purpose of the gentleman from New York.
Strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, many of the policies that this amendment and the majority choose to put under the umbrella label of sanctuary cities or sanctuary policies are in fact simply saying, hey, we have a policy of community policing. We depend on people to step forward as witnesses. We depend on people to report crimes. We depend on people to cooperate with law enforcement. And if they know or suspect that if they do so, that will turn law enforcement's attention in their direction in terms of deportation, then we will get less reporting of crimes, we will get less witnesses, we will get less information, and our community will be less safe. That's a perfectly rational judgment that a local government may make. The gentleman from Idaho says, well, we're not telling anybody what to do. We're not commandeering the state. We're simply saying a state or local government may not tell its officer what to do. The officer must make the decision because we're getting in between. The federal government is interposing its authority between the policeman on the beat or policewoman on the beat and his commanding officer. And his commanding officer may not tell him, hey, you know, don't reveal certain people to ICE because it may reduce cooperation and trust with the police. And the fact, besides being obnoxious in that it's no business of the federal government to get in between the police commissioner and the individual police person and to assert its authority within the mechanism of the local government. Second of all, it's a perfectly rational judgment. It's not ours to second guess when the local government decides this is the better way to keep our people safe. Many local governments have made those determinations and have found that, in fact, community policing, getting trust in all kinds of communities, including immigrant and other communities, is the better way of getting cooperation and getting domestic abuse reported, getting other things reported, getting witnesses to turn up. And what we're doing here is interfering with that because we know best. Whatever happened to that good old Republican doctrine that local government knows best? We're saying we know best, and we're going to prohibit you from doing this kind of community policing. We're going to put a roadblock in the way, and we're going to make your communities less safe as a result. That's what this amendment will mitigate that damage, and I support the amendment, and I yield back.
Mr. Chairman.
For the purpose of the gentleman from Florida, seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I oppose sanctuary policies, and I believe that the underlying legislation offered by Mr. Labrador is but a modest down payment on reforms that are needed to ensure that we have true public safety and that we have the tools at our disposal throughout the entire apparatus of government to keep our people safe. It's noteworthy that during a 20-month period beginning in 2014, there was a study done of the 8,145 illegal aliens who were released as a consequence of sanctuary policies. 5,132 of them, or 63%, had previous criminal convictions or were marked as public safety concerns. Of those 8,145 who were released during this period as a result of sanctuary policies, 1,867 were subsequently rearrested for a total of 4,298 additional arrests and additional charges. It was mentioned that it's really no business of the federal government to be involved in whether or not communities have sanctuary policies. It was said that we shouldn't second guess their decisions. And so that really ripens the question before us well beyond immigration policy. The question is whether or not localities should be able to pick and choose which federal laws are followed and enforced. It was mentioned that it's truly Republican doctrine to just allow local communities to do what they want. That's not true. It was 100 years ago that Republicans in Congress passed a bill to punish counties that failed to enact anti-lynching ordinances. Democrats at the time objected. They said that locals should determine whether or not there are anti-lynching policies, sort of a sanctuary policy for this terrible practice. In Arkansas, there was a decision at the local level to fight against desegregation policies. And I don't think it was wrong that we put federal assets in place to march those minority children into those classrooms, because we decided that Little Rock, Arkansas wouldn't be a sanctuary from the anti-discrimination policies that were so important to the country. What about voting rights? What about equal rights? What about free speech? What about freedom of the press? I think it's very clear that we have to have federal standards that ensure safety, security, and access to the rights that we all hold so dear. So I will oppose a sanctuary in this instance with immigration, and I certainly don't believe we ought to have any circumstance in the country where local governments get to pick and choose the laws that they follow or not follow. And in terms of the specific reforms that the Labrador bill offers, we should absolutely fight against a local government that stands between law enforcement and coordination and cooperation with those at ICE. And with that, I yield back.
Would the gentleman yield?
Yes.
I appreciate the gentleman's remarks. I think they're spot on. And I want to add to them that there is precious little evidence that cooperation between federal and local law enforcement will cause immigrants, even unlawful aliens, to stop reporting crimes.
Oh, my God.
Victims
Mr. Chairman?
and witnesses to crimes are not targets for immigration law enforcement, a point that is repeatedly emphasized by ICE and local law enforcement in outreach to immigrant communities. In fact, victims and witnesses are eligible for immigration relief, such as T visas for trafficking victims and U visas for crime victims. These tools have proven to be much more powerful way to encourage cooperation from the immigrant community than non-cooperation with federal law enforcement or sanctuary policies. I thank the gentleman for yielding. For purpose, the
Chairman?
gentleman from Texas seek recognition.
Strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I think that we all have to respect the men and women who serve in ICE and Customs and Border Protection and serve in our federal service. But there is no doubt that as this new president has come into office, the image of ICE has been the deportation task force, and the fear has accelerated, and that fear has caved opportunities for cooperation with police on the local level. The Major Cities Chiefs Association, representing the police departments from all major metropolitan areas of the country, has opposed this bill because it will make their jobs harder. We respectfully ask that Congress leave to local government the decisions related to how local government enforcement can allocate their resources, direct their workforce, define the duties of their employees. We heard from chiefs of police and sheriffs just a week ago that sanctuary policies don't work. And by the way, that is the word of Republicans. There is no sanctuary policy. There is no big tent that everybody's hiding under. Yes, there are people so frightened that they're hiding in churches, and of course, they've been grabbed out of churches by federal law enforcement. If that is their desire under this president, then that's what they have to do. But local police chiefs have said the role of the local police officers relating to immigration enforcement should be left to local government. They're not the federal agents. And surely it is not good public policy to force an unwanted role upon police through the threat of sanctions or withholding of police assistance funding. You are undermining the very organization that is responsible locally for law and order. And you are pulling people out that have perpetrated no crime. In an op-ed published in Roll Call in 2014, the police chief for Dayton, Ohio, wrote that the then SAFE Act, which this is just a giant SAFE Act, would be an unmitigated disaster. that would actually make our communities less safe. And I know the intentions of my good friend may be, in his perception, good, but it's an unmitigated disaster. Now, my good friend who was giving us a history in race relations and civil rights, I wish I could get enthusiastic about it, but those were the Dixiecrats, and we know them. My question is where the Attorney General was as he lived and promoted segregationist policies in Alabama. He's not yesteryear. He's the Attorney General of the United States of America. He promoted segregationist policies, acted under them. We have no notation that he was standing up supporting Dr. Martin Luther King when he was marching in Selma, marching in Montgomery, or marching in Birmingham. So I don't want to have race brought up of yesteryear. We want to talk about what's going on today. Muslim ban against Muslims, many instances are individuals of color. This immigration policy that goes against, in large measure, people of color. It is frightening. And I remember sitting in this committee when the whole audience was filled with people from Ireland. And they were begging for an immigration policy that would allow them to stay in the United States. And there were members on this podium that acknowledged the Polish. So immigration policies impact all communities. We don't need to bring up the question of race or what somebody did 50 years ago. I'm worried about what they're doing now. And I frankly believe that this is a dastardly bill with bad consequences and punishing of cities. And so I want to support the Lawford Amendment. And I'd be happy to support the Lawford Amendment. Yield to the gentlelady.
Thank you. I would like to know, the chairman indicated that there was no evidence that immigrant communities, I think I heard him correctly, had not cooperated with the police because of immigration. I'd like to ask unanimous consent to put into the record a article in the Los Angeles Times quoting the chief of police of Los Angeles talking about a 25% drop-off in reporting from immigrant communities of sexual assault that is not matched in other communities, as well as an article in the Houston paper from the police chief there indicating that the reporting of crime among Hispanics is down 42.8%, and that's sexual assault and other violent crimes down 13%. That is not matched in other communities. It's clear that immigration enforcement is having a huge impact, and I'd ask...
The time of the gentlewoman has expired.
And will
Without
these
objection,
articles-
the documents will be made a part of the record. For our purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
Is recognized for 5 minutes.
I thank the gentlelady for offering this amendment and strongly support it. I would like first to quote from a letter we received from a number of police chiefs all throughout the country in opposition to this bill, and they say very aptly, immigration enforcement is first and foremost a federal responsibility. Immigration enforcement at the state and local levels divert limited resources from public safety. State and local law enforcement agencies face tight budgets and should not be charged with the federal government's role in enforcing federal immigration law. They go on to say, additionally, state and local law enforcement need the trust of our communities to do our primary job, which is apprehending criminals and protecting the public. They go on to say, legislation like the SAFE Act threatens to undermine trust between immigrant communities and state and local law enforcement. When state and local law enforcement agencies are required to enforce federal immigration laws, undocumented residents may become fearful that they or people they know will be exposed to immigration officials and are less likely to cooperate. This undermines trust between law enforcement and these communities, creating breeding grounds for criminal enterprises. That is the position virtually of every law enforcement officer that has spoken about this and that has written to this committee or that I've spoken to personally. We all understand we have no greater responsibility than the safety of our communities. And this provision particularly will make our communities less safe. And rather than a bunch of legislators in Washington getting to make decisions about how police departments run, Why not rely on the people who are actually doing the work, who have real expertise, who have been trained in the area of public safety? I know this from my own experience. We had a community trust policy in the city of Providence, and as a result of the relationship was built up between the community and the police of trust, we had the lowest crime rate the city of Providence had in 40 years. That's a fact. And that is repeated all across the country, which is why police officers and public safety commissioners, those who are on the ground doing this work, acknowledge that this will make communities less safe. And so the irony of punishing communities that have made public safety a priority by having community trust policies, by punishing them, by denying them COPS funding or burn grants, seems to me a cruel, cruel irony. With all due respect to everyone on this committee, I think we have to respect the judgment of police chiefs and public safety commissioners who are doing very difficult work to keep our communities safe. Their judgment should be respected, and the idea that any member of this committee has a better sense of how police departments should operationalize their work, I think is an absurdity. And the suggestion that, immigrants fearful that the local police departments will enforce immigration law will have no impact because they're not the targets of law enforcement. Well, surely that's true, they're not the targets, but it's the question of what is the perception of that undocumented person? Are they fearful? And the overwhelming evidence is, and the gentlelady from California referenced some, there's so much additional evidence that people who are uncertain about what the law enforcement response will be to their immigration status are less willing to take the risk of coming forward and reporting crime or showing up to be a witness. And there are examples of that all across the country. This proposal, though dressed up in the idea of enhancing public safety, makes our communities less safe. We have received from the Fraternal Order of Police, from the National Sheriff's Association, from the major cities' chiefs, and on and on and on. The considered judgment of experienced, qualified professionals who lead police departments all across this country that say this will make our communities less safe. It will make our responsibility of keeping residents of our cities and towns safe more difficult. I strongly urge my colleagues to put aside whatever their preconceived notions are of what this means. Listen to the experts who actually do this work, who are saying the trust and confidence of the members of our community matters. And my police chief used to say, the most powerful asset I have in the police department is not a tank, is not a gun, it's the trust and confidence of the community we serve. That's the most powerful tool, the most powerful weapon in fighting crime. Let's respect the judgment of police chiefs who say that, support this amendment, and I thank the gentlelady for submitting it, and I yield back.
First, the gentleman from Louisiana, seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This is a big issue in my home state of Louisiana. In fact, our state legislature is meeting as we speak and debating a sanctuary cities ban in state law there. I was in the legislature last year and helped lead that charge. We lost the bill in committee, but they brought it up again because it's important. In my state, the city of New Orleans has been in flagrant violation of federal immigration laws. They're one of about 200 cities that have been cited, as has been mentioned, the Department of Justice's report about cities that have not complied with the request from ICE to detain undocumented immigrants for potential deportation. We have to allow ICE to do its job. I just want to go on record, Mr. Chairman, as agreeing with Representative Labrador's bill wholeheartedly and opposing this and the other amendments because I think it's an effort to weaken it. John Adams famously compared our republic, the idea, the principle of our republic, to an empire. In his day, people were trying to understand the difference and the distinction, and he famously said, of course, that we're a nation of laws and not of men. What he meant by that is that the rule of law is important to our form of government, that we have to comply with the law, and as much as we would want to give discretion to local officials, as has been argued here, we can't do that. We have to comply with the letter of the law. If we allow local officials to decide on their own whims which laws they want to comply with and which they do not, then we lose the essence of our republic, that we're a nation of laws and not of men. So these are the overarching principles behind all this. It doesn't mean that Republicans and those who support this bill lack compassion for immigrants or anything. It just means that we have to maintain our system of justice and the rules that underlie that. And so if anyone tells you that we are lacking in compassion, that's simply not the case. We just want to make sure that the law is complied with, because not only is it a matter of principle, it's also a matter of national security. And we know that dangerous persons are coming across the porous southern border and in other ways, and they're finding sanctuary in these cities. So the facts are the facts. We should remove the emotion from the debate, and we should support common sense legislation like
Will the
this.
gentleman yield?
I'll yield.
You just made the claim that this is somehow authorizing local communities to not follow federal law. I would just ask, the provisions actually shift responsibility or punish communities who refuse to accept responsibility for the enforcement of federal immigration law. There is, in fact, no suggestion in this bill, nor of any use of any of these cities, that people are breaking the law. The question is different. It's not whether or not cities are required to follow federal law. It's whether or not we can punish communities who refuse to accept the responsibility of enforcing federal immigration law, which I think is a different question, because there is nobody on this committee, I think, who's suggesting that local communities are permitted to violate federal law. That's a different question than saying, is it appropriate to require a local community to take on the responsibility and burden of enforcing federal immigration law when the local police department is saying, we don't think this is helpful in keeping our communities safe? It's a different question. And so I would just push back very hard on the idea that anyone who's opposing this bill is doing it because we think local communities should be permitted to break the law and pick what laws to enforce or not. We're talking about police departments.
Well,
they take enforcing the law and abiding by the law and upholding the law very seriously. And so I don't know of any community trust city or town that is breaking federal law. That is a very different question than saying we are going to impose on you the requirement that you enforce federal immigration law.
Respect my colleague very much, but I would say that we could parse the language and engage in semantics on this all day long. You portray this as, well, we've decided on the local level that it's a, quote, undue burden on us to enforce this particular federal law. But where does that argument go? If you take it to its full and logical conclusion, it means that everyone can decide at any time whatever they subjectively regard to be an undue burden. Well, I don't like this federal law. I don't like this federal provision. I don't like this mandate.
The gentleman,
We can't do that. And so I think it's important for us to acknowledge that we here are elected representatives of the people. Each of us respectively represents about 750,000 people. We came here to be their voice, and the voice of the people say that the rule of law is important, not only, as I said, because it's a fundamental principle of our republic, but because it's important for public safety. So our discussions and engagement about how you could characterize a local official's unwillingness to enforce a federal law, I don't think it matters. I think at the end of the day, the law is the law. The rule of law should control, and we should enforce it. With that, I yield back. I yield.
I just want to note that there are a myriad of federal laws, and we're not asking local police departments to enforce securities laws or banking laws or antitrust laws or other laws. We've picked immigration out, and we're saying we will cut off your funds that would help you combat terrorism and nuclear proliferation that by terrorists because of this one issue of immigration. It's not all federal law. It's just anti-immigrant laws, and I thank the gentleman for yielding.
Question occurs on the amendment offered by
Mr.
the
Chairman.
gentlewoman from What purpose did the gentlewoman from Washington seek recognition?
Move to strike the last word.
Gentlewoman's recognized for 5 minutes.
Thank you, Mr. Chairman. I wanted to rise in strong support of this amendment from Representative Lofgren. I think it's incredibly important, and it reflects the commitment to public safety across the country to say that we respect what local law enforcement has to say about how you actually enforce public safety in communities. And I think there is ample evidence, Mr. Chairman, that in fact, combining or asking local law enforcement to enforce federal immigration law, two completely different systems. Federal immigration law is a civil system, it's a federal system. Local law enforcement has the obligation to protect communities. And what we know about protecting communities is that when people trust that they can come forward and speak about crimes, when people know that they can report domestic violence, when people know that they are not going to be asked about immigration status, they are going to, in fact, contribute to the safety of the community. And I respect that my colleague from Florida mentioned how committed he is to issues of sexual violence and prevention of sexual violence. And I would say that if he is in fact, and anybody on this committee is in fact committed to preventing sexual violence, then what we should do is not pass this bill. That is the most important thing that we can do to protect victims of domestic violence and sexual assault. And I wanted to submit for the record, Mr. Chairman, a letter from the National Task Force to End Sexual and Domestic Violence on this bill, and specifically wanted to just quote that a provision of this where they talk about the difficulties, particularly in the last several months, of people coming forward to report any kind of sexual assault. And I wanted to just quote the statistics that are in this survey: a total of 715 victim advocates and attorneys in 46 states and the District of Columbia that participated in this. And the survey documented that 78% of advocates reported that immigrant survivors express concerns about contacting police, that similarly 3 in 4 service providers responding to the survey reported that immigrant survivors have concerns about going to court for a matter related to the abuser or offender, and finally 43% of advocates who worked with immigrant survivors who dropped civil or criminal cases because they were fearful to continue with their cases. And so I think that the proof is clear that what we are doing as we ramp up a mass deportation force, this administration's mass deportation force, and let's be clear, this bill is not the SAFE Act, it's Trump's Mass Deportation Act, that what we're doing is we're actually undermining public safety and public trust. Because don't forget that 17 million undocumented immigrants live in mixed status families. That means that somebody in your family is either a citizen or a permanent resident or has legal status, but somebody else does not. So it's not so easy to say, well, we're going to protect, we're only talking about undocumented immigrants, this isn't going to hurt anything. It absolutely does. Mothers do not come forward even to get benefits for their families that they're entitled to as legal permanent residents if they're concerned that somebody is going to ask about the undocumented status of somebody in their family. And that's why I'm proud to have helped actually pass what we call the Welcoming Communities Act in Seattle, which was what you call a sanctuary cities policy. If that means that we are actually protecting our community and protecting the rights of domestic violence victims and sexual assault victims and people who are trying to actually report crimes and are contributing to our communities, then I'm proud to call it whatever you want to call it. It's the right policy. And this amendment tries to make a really terrible bill slightly better by saying that we are actually going to respect that what we need in order to protect public safety across this country is the cooperation of communities and law enforcement. I had submitted earlier for the record, also, Mr. Chairman, a letter from our King County prosecutor, Dan Satterberg, who also spoke about how important it is to protect this distinction and not have local law enforcement trying to enforce immigration law, and certainly should not be subject to punishment if they actually do what they think is going to protect public safety, which is to have cooperation with the community. And Mr. Chairman, I would like to ask if I can submit this letter from the National Task Force to End Sexual and Domestic Violence for the record.
Without objection, will be made a part of the record.
Thank you, Mr. Chairman. I yield back.
The question occurs.
Move to the strike the last word.
Gentleman is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I rise in very strong favor of the amendment offered by the gentlewoman from California. I was fascinated by the colloquy between Mr. Cicilline from Rhode Island and my friend Mr. Johnson from Louisiana. And Mr. Cicilline makes the point that Congresswoman Jayapal was just making, which is that we are hearing from police officers and law enforcement officials and organizations from across the country to tell us, don't do this. It will make our communities much less safe. It will undermine social cohesion, and it will undermine the willingness of people to come forward to talk about sexual assault or rape or wage theft or violence in the communities, because it will instill or deepen a regime of fear in affected communities. Mr. Cicilline speaks as a former distinguished mayor, of course, the mayor of Providence, and he says, this is not what we need, and this is an imposition on the local governments, which is why we've heard, for example, from the Major Cities Chiefs Association saying, we respectfully ask that Congress leave to local government the decisions related to how local law enforcement agencies allocate their resources, direct their workforce, and define the duties of their employees. The role of police officers relating to immigration enforcement should be left to local government. Surely it's not good public policy to force an unwanted role upon police through the threat of sanctions or withholding of police assistance funding. Well, my distinguished colleague from Louisiana says, ideally, presumably, we would leave this to the local governments, to the operation of federalism, but it's too serious because we need to enforce the law. Well, at this point, we have to turn to the Constitution then, because some of us are saying millions of people's security and safety is actually being put in danger by these policies, and others say, well, we've got to enforce the federal law. Well, what does the Constitution say about it? In the Prince decision in 1997, the Supreme Court struck down a provision of the Brady Handgun Violence Prevention Act, which required the chief law enforcement officers of each jurisdiction only do a background check on people trying to purchase a handgun. But it required the local government officials to do it, the chief law enforcement officer of each county or city. And the Supreme Court struck it down, saying this was an unfunded mandate and it was a, quote, commandeering of local governments by the federal government. The Supreme Court struck it down. Now, they could argue, if I were on their side, I would argue, well, of course, that was telling the local governments they had to do it. Here they're not saying, you got to do it. They're just saying, we're going to strip you of hundreds of millions or billions of dollars across the country if you don't do it. But we've got a case on that too, because the Supreme Court has repeatedly said you can't do to the local governments indirectly what you can't do to the local governments directly. And what is it to say if you don't toe the line on our enforcing our federal immigration policy for us, if you don't do that, we're going to strip anti-terrorism funding from you. We're going to take away other DOJ grants from you. What that is a Godfather offer. We'll make you an offer you can't refuse if you want to meet all of the other public mandates that are part of your responsibility. But the Supreme Court in the ACA case, in the Sebelius decision, just in 2012, said Congress can't do that either. Now remember, what happened there was, in the ACA, Congress had said, if you don't participate in the expansion of Medicaid, we're not only going to deny you the money that goes with the expansion, we're going to revoke all the other Medicaid funding you have. We're going to punish you seriously for doing that. And the Supreme Court said no. That's a Godfather offer. That's twisting the arm. That's extortionate. The federal government can't do it. The provision that this amendment seeks to delete is unconstitutional because it proposes to delete funding from local governments for things completely unrelated to the purpose of the enactment in itself. It's saying, if you don't play ball with us by becoming our instruments, by becoming essentially employees of the federal government on immigration enforcement, we're going to take away all these other funds from you. And the Supreme Court has said, you can't do that. This is in violation of the Prince case. It's in violation of the Sebelius decision, which I know my friends on the other side of the aisle cheered in terms of dismantling that provision of the Affordable Care Act. And it is an assault on the basic structure of federalism that's in our Constitution. So let's listen to the mayors, let's listen to the police chiefs, let's listen to the officers, and let's follow the Constitution of the United States. I yield back.
Question occurs on the amendment offered by the gentlewoman from California. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it.
Recorded vote.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? No. Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
Gentleman from Ohio.
Mr. Jordan votes no.
Gentleman from Pennsylvania.
Mr. Marino votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 12 members voted aye, 16 members voted no.
And the amendment is not agreed to. For what purpose the gentleman from California seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 2431 offered by Ms. Lofgren. Strike section
Without
6.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on her amendment.
Mr. Chairman, this amendment strikes section 610, which is maybe the most heartless provision in this heartless bill. Section 610 states that children who enter the country with their parents must be detained and subjected to mandatory detention and expedited removal, that no child may be released to anyone other than a parent or legal guardian under any circumstances, even if they've obtained legal relief, such as special immigrant juvenile visa or relief under asylum. And the section also clarifies that specific licensing requirements may not be imposed. This amendment strikes all of this and restores the current judicial findings that limit the length of detention of children and other safeguards. There was a settlement years ago called the Flores Settlement, and there have been subsequent judicial decisions about the Flores Settlement, and it deals with how children are treated in U.S. detention centers. The Flores requirement requires that children be released from custody without unnecessary delay, with the preferential release to their parents in accordance with family reunification requirements, and that children be held in the least restrictive setting appropriate to age and special needs, generally in a non-secure facility licensed by child welfare entities and separated from unrelated adults and delinquent offenders. Now, this is important because child psychologists have found that the detention of children is detrimental to their health. And this is what was said in Lancet, the prestigious medical journal, and I quote, "Immigrant detention can cause the development and maintenance of psychiatric difficulties, with children and adolescents in detention reporting increased rates of deliberate self-harm, suicidal behavior, voluntary starvation, severe depression, sleep difficulties, somatic complaints, anxiety, and post-traumatic stress reactions. These negative psychological outcomes affect broad domains of functioning and probably adversely affect physical and academic development. Reports are common of poor nutritional access, regression in language development, bedwetting, and social withdrawal in children." You know, the Dean of Social Work at the University of Texas at Austin, Dr. Luis Zayas, interviewed several families at the Karnes County Residential Center in 2014. And he found that many of the children who he interviewed, and this was in his affidavit, had negative consequences. He said that detention has had a serious and long-lasting impact on the psychological well-being of the families I interviewed at Carnes. The bill also removes the provision that the child be kept in a facility that's licensed for child care. Now, why does this matter? Private prisons that are operating in Texas, which I've visited, sought to be licensed as child care facilities, absurd as that is. These prisons were not established to care for or provide services to children for their welfare. They're designed as prisons. And Texas they were denied licensing by the courts. The bill would circumvent the argument and say that licensing isn't required so that these children could be held in prison. Now, the majority has talked a lot about immigrants as criminals. But I'll tell you about the children I saw when Mr. Gutierrez and I and others went to Texas. We met hundreds of mothers and hundreds of children, many of them 4, 5, and 6 years old. These mothers and their children had come primarily from Central America, and they were seeking asylum in the United States. They fled violence. The 3 countries in Central America have the highest murder rates of any place in the world, and the women who we spoke with had fled for their lives. We met children who had spent a quarter of their life in prison, and many of these children were sick. They were having tremendous psychological difficulties, and it was really, I thought, you know what, this is not what America does. Put little 4-year-olds in prison. That's not the kind of country that we are. And subsequent to that visit, Judge Gee, federal district court judge in Los Angeles, ruled that the Flores case did apply to children who were accompanied by their mothers. And so now there is a temporary detention only, and children and their mothers are released to the least restrictive place.
Time of the gentlewoman has expired. For purpose of the gentleman,
May I ask for 30 seconds additional?
without objection, the gentlewoman is recommended for additional 30 seconds.
I would just say that of all the things that are in this bill, this is the most heartless, most really obscene, miserable attack on the well-being of children who have done no crime, who've done nothing wrong. I just think it is not the American way, and I yield back.
The gentleman from Idaho is recognized for 5 minutes.
Mr. Chairman, I oppose this amendment. And if you want to talk about obscene, maybe you can talk about the argument that was just made. When the Flores settlement agreement was reached in the 1990s, it was established that unaccompanied minors entering the United States were presumed to be eligible for release from detention. Under the terms of the 1997 agreement, the government is required to release minors without unnecessary delay to the parents, other adult relatives, or licensed programs. In addition, the government must place them in the least restrictive setting if no other suitable placement can be found, and must implement standards as to the care and treatment of unaccompanied minors in immigration detention. While we could debate for hours the merits of the settlement agreement, something that no one expected the settlement agreement to do was for it to be extended to minors who are accompanied by their parents. With the border surges in the past few years, the courts have re-examined the Flores settlement. On July 6, 2016, the Ninth Circuit in Flores versus Lynch held that the terms of the settlement agreement applied to all minors, including those that are accompanied by their parents. This is absurd at its worst. The crux of the original agreement was to ensure that unaccompanied minors were placed with parents already living in the United States. When a minor enters with their parents, where is the child supposed to go if released? Either the parents also have to be released, encouraging illegal immigration, or the minor will essentially be abandoned. If indeed the minor can care for themselves, then this again encourages more minors to make the perilous illicit journey to the U.S., where many of them have been raped, they have been harmed, and have been killed. How is it in their best interest to be separated from the parents, especially if they have no grounds to remain in the United States and are shortly to be removed? The Davis-Oliver Act reverses this illogical result. By eliminating the presumption, the discretion to release accompanied minors from family detention is placed back where it belongs, with the Secretary of Homeland Security. The Immigration and Nationality Act has several provisions allowing for either release or continued detention for aliens. As these cases present a much different case than unaccompanied children, it is best for the Secretary to use the factors established to determine eligibility for release. Simply reading the Flores Settlement Agreement makes it clear that this was never intended, ever, for anyone other than unaccompanied minors. We must now return to the plain meaning of the agreement and the application of the statute, and I urge my colleagues to.
Would the gentleman yield?
Yes.
I thank the gentleman for his observations, and I'll tell you what I think is obscene. What I think is obscene is separating young children from their parents, as the current interpretation by the courts makes clear. And it is also very clear that the Obama administration agreed with the concern that you and I have about that California decision because they appealed it to the Ninth Circuit. The former Secretary of the Department of Homeland Security, Mr. Jay Johnson, appealed that wrongful decision. We ought to fix it here, we ought to fix it in this bill, and that's why I oppose the gentleman's amendment. Question occurs on
Move
the
to
amendment.
strike the last word, Mr. Chairman.
Gentleman is recognized for 5 minutes.
Thank you. Well, first of all, I hope, since this is the Judiciary Committee, we would understand something fundamental about the Constitution, and that there are checks and balances, and that the legislative branch of government shouldn't just say, well, the president did it, so it must be okay. I understand how the majority might say that since they believe that everything the current president does is okay. But unlike the majority, the minority side actually challenged President Barack Obama, actually challenged the Secretary of Homeland Security, people that we cared a great deal about personally and politically, people who we voted for and championed. But when we saw them do what was wrong, we challenged them, which is what I think, since I didn't get to meet, George Washington and the other gang, everybody keeps talking about them like they knew them, like they were their neighbors. The founders. I mean, people talk about them like they're cousins, maybe once removed. But I never got to meet any of those guys because it was all guys that got to do it. Look, we challenged them, and so Zoe Lawford and I and a group went down there. And I was simply suggested the majority visit detention centers. Now, I know the majority's really into private prisons. And if you're into private prisons and handing over the keys from the government to private entities, only goal is profit. Then you can do that. But Congressman Lawford and I saw what profit does. It means that you are going to have children not have the medical care that they need because it's profit. They don't want to give doctors and nurses because the food that they eat will be substandard because it's about profit. The conditions and their housing and their bedding will be minimal because it's profit. Now, and the other thing, I think it's obscene to talk about people who are fleeing organized crime elements in Honduras, El Salvador, like you have never seen, where there is no civil society, where you just don't dial 911 and expect the police to show up. That's what they are fleeing with their children. What are they fleeing? Murder, rape, dismemberment. That's what they're doing to people. So they're fleeing. So stop calling them illegal immigrants to the United States. No, what they are is under our law seeking asylum in the United States of America, and they are refugees to this country. Cannot we not make that basic distinction between somebody who comes here seeking work? They stay in their country. It's not about them being able to earn a living. They can earn a living in their country. What they can't do in their country is survive, is live without the imminent fear of death. And the majority party likes to talk about children. Well, these are children. That's what they are. You should meet these children and see the tears in their eyes and see the effect. I want you to think of a 3-year-old, a 4-year-old, a 5-year-old. Do you have that child in your mind, a 2-year-old? And then I want you to think of that child spending 1 month, 2 months, 3 months, 4 months, a year, right? So we found them for a year. Sorry, Congressman Lofgren, we found them for a year. And we challenged President Barack Obama, and you know what? He changed the policy and they were released. And I'm happy that we had lawyers go back to the Flores decision, because it is about children in the end. I just want you to think about children, 4, 5, 6, 7-year-olds, who have already seen incredible violence, and they're fleeing, and they go through this torturous, dangerous, filled with minefields coming through Mexico to reach our border, and finally they reach the United States of America. And what do? They're jailed once again, and they're treated inhumanely once again. What happened? What happened to the United States of America? So I know the majority wants to send a message, don't come to America, because this is what's going to happen to you. I think it's the wrong message. And if we really want to send a very clear message, then let's have a real war on drugs. Because the drugs that we consume as Americans is what causes the destabilization of the country and the undermining of the underpinnings of democracy in those nations, making those people have to flee to come to the United States of America. So let's first think about giving them freedom in their own countries. Thank you, Mr. Chairman.
Mr. Chairman,
For purpose, the gentleman from Rhode Island, seek
I
recognition.
move to strike the last word.
Gentleman's recognized for 5 minutes.
I rise in strong support of the gentlelady's amendment and thank her for submitting it. And I, too, would like to describe this as the worst provision of a very, very bad piece of legislation. We have, in this country, prided ourselves on a very long period of jurisprudence that focuses on treating children in a very special way. We make decisions that require that decisions be made that are in the best interest of the child. That is the standard. And that in making determinations about placements of children, that always be done in the least restrictive setting. That's not just something we pulled out of the air. That's as a result of decades and decades of work done in child welfare and research that demonstrates that we treat children differently because they're often in situations not of their own making. And we treat them differently because the impact of placing them in different settings, more restrictive settings, or keeping them in custody, have devastating impacts. Children are not able to withstand those conditions or those events in the same way a mature adult can. And that's why there is so much literature and good research that, and I'm going to quote here from the Lancet Journal, which is a very prestigious medical journal, that said immigrant detention can cause the development and maintenance of psychiatric difficulties with children and adolescents in detention, reporting increased rates of deliberate self-harm and suicidal behavior, voluntary starvation, severe depression, sleep difficulties, somatic complaints, anxiety, and post-traumatic stress reactions. We all know that from the literature we've read, from the conversations we've had with young people who have been held in detention. What this provision does is it goes out of the way to say there is no presumption that a child should be released from detention. They go out of their way to say, make sure you don't think there's a presumption that a child, that we typically say, we have to make a decision in the best interest of the child in the least restrictive setting. And then it goes on to say, in no circumstance shall a child who is an unaccompanied child be released by the Secretary of Homeland Security other than to a parent or legal guardian. And so that in those circumstances, it makes detention necessary, even in those circumstances that a child may have obtained some relief as a special immigrant, juvenile visa, or relief under our asylum system. This is sort of going out of the way to be extra cruel and impose particular harm on children who, as Mr. Gutierrez said, are often coming here fleeing unspeakable violence and having already been traumatized dramatically and in very devastating ways by their journey and by the experiences in their home country. In addition to that, if getting rid of a presumption demanding that children be detained wasn't enough for you, enough evidence to show how cruel this is to children. This provision also removes the provision that children be kept in a facility licensed for childcare. It goes on and says that there is the conditions of confinement applicable under this statute. What kind of place you want to put the child in is completely up to the discretion of the secretary, and in no instance may specific licensing requirements be imposed beyond those deemed appropriate by the secretary. Really? We don't hear anything about the standard of care, about the appropriateness of the facility? I mean, we are better than this. We're not talking about criminals. We're talking about children who have left their home country, and in order to do that, undergo a traumatic and difficult journey, leaving conditions that are often life-threatening. And when they arrive in the shores or on the door of America, we guarantee we hold them in custody. We guarantee there's no standards for their care. This is a terrible, terrible provision of a terrible bill. I think we are better than this. I urge my colleagues, no matter what you do on the bill, find it in your hearts to do the right thing, to follow the tradition of the best interests of the child in the least restrictive settings, which has been the law of the land all across America for decades, maybe centuries. Let's maintain that. Let's have the dignity to stand up and say, no matter where we stand on the issue of immigration, we will not surrender a proud tradition of protecting children and treating them in a special way, however they arrive in America. And with that, I thank the gentlelady for submitting the amendment and look forward
Mr.
to it.
Chairman,
What purpose does the gentlewoman from Washington seek recognition?
move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank my colleague, Ms. Lofgren, for offering this amendment to stop the committee from expanding mandatory detention without the safeguard of licensing standards of parents with their children. The detention of children and families itself is shameful. It's a new low, and quite frankly, I find it embarrassing that the Committee on the Judiciary would also consider taking away these critical licensing standards for these facilities. The American Academy of Pediatrics has criticized family detention facilities because they do not meet the basic standards of care of children in residential settings. And as was said, in August of 2015, a U.S. District Court in California found that family detention centers are in violation of the Flores Settlement Agreement. There have been multiple complaints about the conditions of family detention, and yet a mountain of evidence and a court order. In spite of that, DHS continues to detain children. One of those children is 8-year-old Angelo, who was unnecessarily detained at the Dilley Family Detention Center for 6 months. And as has been said here by Mr. Gutierrez and Ms. Lofgren, I think it is important to think about who we are talking about. And so I bring Angelo's story here to ground us again in the real stories of the children we're talking about. He and his parents fled Honduras after his mother was persecuted for her vocal opposition to police corruption, abuses, and impunity. Angelo's grandmother also was a vocal critic of police corruption and was murdered in 2006. In Honduras, Angelo witnessed the police beating his mother in their home. At age 6, Mr. Chairman, he saw a dead body during a stay with his grandparents. Here in the United States, the asylum officer who interviewed him noted the difficulty with which he spoke about what he had witnessed in Honduras. Being detained significantly exacerbated Angelo's trauma. An immigration judge ordered that he be released into his aunt's custody on 3 separate occasions, but ICE refused. And at one point, ICE told Angelo and his mother that they were taking him to what was described as an orphanage, leaving Angelo sobbing uncontrollably. Angelo and his mom chose to suffer together in detention rather than being separated indefinitely without guarantee that Angelo would be released to his aunt. Angelo was granted asylum after his release from detention and is currently in the process of applying for permanent residency. He and his mother have filed a federal lawsuit against the federal government for the abuse, coercion, and prolonged detention that they suffered during their detention. Mr. Chairman, before I came to this body, I had the opportunity to run a national campaign called We Belong Together. And every year we would bring hundreds of children to the Capitol in something called Wish for the Holidays. This was an opportunity for Congress members to meet the children that we're talking about and to actually be in a situation where they would be face to face and hear the stories of people, kids like Angelo, kids, 6 years, 7 years, 8 years. And what Ms. Lofgren's amendment does is it does not eliminate all detention, unfortunately. That's what I wish we could actually begin to get at. But what it does is very sensible. It just says no mandatory detention. And by the way, if you're going to detain in facilities, let's make sure that they meet the licensing standards. That is not excessive or egregious. That's just humane. And I hate to imagine what family detention would look like if this Trump Mass Deportation Act passed without this amendment. The bill would condemn children like Angelo to long-term mandatory detention in facilities that wouldn't even be required to obtain licenses to detain children. How is this justice, Mr. Chairman? I also wanted to submit for the record the statement from the U.S. Conference of Catholic Bishops, which is a call to end family detention. And really, from a moral perspective, talking about how inhumane this practice is and how we as a country have to revert back to our basic values of faith and goodness and humanity. If there's no objection, Mr. Chairman, I'd like to submit that for the record.
Without objection, be made a part of the record.
Thank you, Mr. Chairman. This country already tried to detain young children like Angelo with their parents during World War II. It is a stain on our country that we will never erase. We have a moral duty as members of Congress to stand up for what's right. A critical first step is adopting this amendment, but ultimately I hope all of my colleagues on both sides of the aisle will reject the Trump Mass Deportation Act in its entirety and eliminate the immoral practice of detaining families, period. Thank you, Mr. Chairman. I yield back.
For the purpose, the gentleman from Iowa seek recognition.
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in opposition to this amendment, and I think it's important that we have a discussion here that puts this back in a perspective. I've listened as my colleagues on the other side of the aisle that talk with, I'll say, great sympathy and emotion and individual anecdotes that are designed to characterize the broader sections of this bill and the amendment itself. And I'm hearing discussion, for example, such as we have to declare or consider each one of these who have unlawfully entered into America. We can't be calling them illegal aliens anymore, even though that's what the statute says, because they're looking for safety, they're considered to be asylees. And so I was contemplating this safety component, and it's something that's come up in this committee a few times before. But for the last, 6 or 7 or 8 years, I have tracked some of the violent death rates in America. And so I looked at a website that I've long had in my iPhone here, and it says these violent death rates, what would be the highest? Well, you're right, the folks that are critics here, it is El Salvador, 93.09 violent deaths per 100,000. I recall after Katrina in the violent death rate in New Orleans, because of the dynamics involved in some of the people that stayed in New Orleans and others that left, that violent death rate went right to that number. I believe 92 per 100,000 is what Randy Forbes reported after a fact-finding hearing down there. Guatemala is second highest violent death rate in the world, 70.66 violent deaths per 100,000. Venezuela is third. Honduras is 8th. Haiti is 10th. But if you look at the top violent death countries in the world, 8 of the top 10 most violent countries in the world are south of, I'm not going to say the Rio Grande, south of Mexico. Mexico's violent death rate has run triple that of the United States for a long time. And today, you can look back and see that in the last 6 or 7 years, its violent death rate has doubled from about 13.03 violent deaths to over 27 violent deaths per 100,000. So it is true that there's a lot of violence south, and there's a reason maybe to want to get away from that. But if we're going to be objective about this, we ought to look at the violent death rates in America's cities as well. And those violent death rates compete with the violent death rates in the major cities in the rest of the world. We have 3 American cities that are among the 50 most violent cities in the world. And those cities, according to these most current records that I can find here today, are East St. Louis, Baltimore, and Detroit. For some time, up till about a year and a half or so Detroit had the highest violent death rate of any city in America and competed with that in the world. So I recall people then in this committee said, we need to get them out of Guatemala, El Salvador, Honduras, and bring them to America because it's too dangerous where they are. We better be cautious when we talk about that because we have places in this country, and Chicago is really not the most dangerous city in the world or in the United States. But we have to be cautious about that because we might be saying, well, let's bring them to a place even more dangerous if you're advocating for some of these cities. That's one of the points that I think needs to be brought into a more accurate perspective, Mr. Chairman. And then this discussion about sanctuary cities and that we should be very careful that we don't alienate people who are unlawfully in America because they will no longer turn any information over to law enforcement officers. Well, my view is if they're unlawfully present in America, they don't belong here. And so therefore, once we finish this enforcement against the unlawfully present in America, it won't matter because the criminals that they need to testify against and some of the victims are in their home countries, and those countries then can worry about the adjudication of this. And with regard to the gentleman's remarks about the Godfather offer, well, I was listening to that argument. I happen to think that when I drive out on the two-lane highways all across America, I'm by law required to match the double nickel, 55 mile an hour. Well, that also was a Godfather offer, Mr. Chairman. And so there is a whole series of exceptions to that rationale that it's unconstitutional to make an offer that can't be refused. And I would say there's another point that's completely missed in this discussion, and that is this point that local law enforcement and any subdivision of the United States of America should want the law enforced. And so we're offering in this bill an opportunity for the political subdivisions in America to cooperate with the federal government's help to bring their jurisdictions into compliance with the law. And I'd conclude my statement and yield back the balance of my time.
Chair, thanks, gentlemen. We have a amendment, second-degree amendment in the works. Is it ready?
Mr. Chairman.
What purpose the gentleman from Maryland seek recognition?
Move this to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, thank you. But I wanted to start by invoking the great Tom Paine, who assisted us so much in our revolution against Great Britain. And he said that America would become a haven of refuge for people fleeing religious and political repression all over the world. He said that the general state of the world was one of dictatorship, kings, religious despots, anarchy, but America would be a place where people could come seeking freedom, seeking opportunity. That's who we are. Everybody who's here is an immigrant or a descendant of immigrants, except for the Native Americans and the African Americans who were brought over as slaves. But the rest of us, we are here as the progeny of immigrants. And I dare say that a huge number of them, if not the clean majority, came over without the proper papers when they first got here. In fact, we didn't even have a federal immigration system for the beginning of the country, for most of the country. There was no INS. There was no ICE system. So the distinguished gentleman from Iowa says that there's a terrible death rate and terrible violence in El Salvador, in Guatemala, and Honduras. And indeed there is, and our country cannot disown our own complicity in the turbulence and the instability that exists in Central America because of the wars of violence that took place there in the 1980s and in the 1990s. And the disappeared people and the authoritarian thugs who were running those countries, who waged war on their people, who raped nuns, who assassinated human rights activists, and now there is hell to pay in terms of the breakdown of civil order in those societies. And the people who come to America, seeking refuge, the kind of refuge Tom Paine talked about, and have their children, are just like the rest of us who got here. Our parents fleeing Ireland or Italy or Europe or Africa, they are also fleeing political and religious repression and violation of human rights every single day. So this is who we are. The distinguished gentleman talks about the Godfather offer of having a certain speed limit tied to highway funds. And I assume that he knows that he is referring, of course, to a famous Supreme Court decision which allowed precisely that connection, because the Supreme Court said that there was a relevant nexus between the imposition of drunk driving laws or the imposition of speed limit laws and public safety and the provision of federal highway funds. But what the Supreme Court has said, for example, in the Sebelius decision related to Medicaid, is that you can't go beyond the specific logical nexus. So if you want to cut off money for aid to immigrants, if there is any, if all of the local governments don't toe the line and become subordinates, unpaid subordinates of the federal government, fine. But you can't cut off anti-terror financing, and you can't delete other federal programs that have nothing to do with immigration. But of course, that's precisely what this legislation seeks to do. So the invocation of the Prince decision and the invocation of the Sebelius decision were all about making sure that there is a tight logical nexus and not allowing the federal government simply to turn every local government in the country into a bureaucratic functionary of Congress and of the federal government. And I thought that that is a basic principle of federalism that my thoughtful colleague from Iowa would be sensitive to, that we don't commandeer the resources of the local governments. Those taxes are raised by local people for their purposes. Now, let me just say finally, in terms of this amendment, this is the very least that we can do to stand up for these children who have no say over their destiny and the misfortune that has befallen them. Even the Supreme Court of the United States said in Plyler versus Doe, a state cannot reject undocumented children from public school because it's not their fault. And you don't visit the sins, real or imaginary, of the parents upon the children. Let's at least make sure the children have a decent and safe place to be in this process. I yield back, Mr. Chairman.
What purpose does the gentleman from Iowa seek recognition?
Mr. Chairman, I have a second-degree amendment at the desk.
The clerk will report the amendment.
I reserve a point of order.
The clerk will report the amendment. Point of order is reserved.
Amendment to the Lofgren Amendment. Strike section 610 and all that follows and insert on page 178, strike lines 18 through 23.
The gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. There's an issue involved in this amendment that offered by Congresswoman Lofgren about the conditions of confinement within the facilities that are licensed under this existing language in the bill. That what my amendment does is it strikes all of the Lofgren amendment. My second amendment strikes all of the Lofgren amendment, but it inserts the language on page 178. Actually, it inserts on page 178 strike lines 18 through 23. That's the sections of the code that can deal with conditions of confinement. And I'll just read this section. The conditions of confinement, this is what would be struck. The conditions of confinement applicable under this subsection shall be in the discretion of the Secretary, and in no instance may specific licensing requirements be imposed beyond those deemed appropriate by the Secretary of Homeland Security. So that language, what it does is it caps the standards in these facilities at that standard that would be approved by the Secretary. By striking this language under my second-degree amendment, that lifts that cap and allows those conditions, those standards then to be improved and better than the minimum standards that are required under the Secretary of Homeland Security. And so I oppose the basis of the Lofgren Amendment, which is why I offer the second-degree amendment to strike that. But an improvement on this bill would be to lift these licensing requirements so that the standards in those facilities could be improved. And I urge the adoption of my second-degree amendment, and I yield back the balance of my time.
Chair, thanks, gentlemen. Does the gentlewoman insist upon her
No, I don't, and I would like to strike last word.
Gentleman is recognized for 5 minutes.
This does not fix the problem. I'll just give you a real-world example. There is the Burke Center in Pennsylvania. Currently, we have mothers and minor children imprisoned in the Burke Center, which is unlike the centers in Texas, is a local government facility. It's not licensed. And recently, the court said it could not be licensed. It's a jail, and it cannot be licensed as a child care facility. Essentially, that situation in Pennsylvania is what the gentleman from Iowa's amendment would do, but the problem is it doesn't solve the incarceration of children, because the remainder of the bill insists that children may not be released under any circumstances. I would point out, even if they have been granted a benefit under immigration law, if, for example, they have been granted asylum or special immigrant juvenile status, they could not be released because if their parents were in custody. So I don't think this amendment matters. I don't think it fixes the problem in the underlying bill. Whether it passes or not, we can pass it on a voice vote, but it doesn't solve the underlying problem, even though my amendment would have struck this provision, so I wouldn't be against it. It does not solve the underlying problem. And with that, I would yield back.
Question occurs on the amendment to the amendment offered by the gentleman from Iowa. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the amendment to the amendment is adopted. Question now occurs, what purpose the gentleman from Texas seek recognition?
Just one comment. I'm just going to speak to the...
Gentleman is recognized for 5 minutes.
Strike the last word. Just going to speak to the Lawford Amendment without what has been amended. Let me just generally say that for those of us who visited detention centers and worked on issues dealing with the conditions of children over the years, again, this bill is a punitive bill. It goes against all sense of humanity as it relates to children who are innocent, and it does not follow the basic understanding of the Flores settlement, which is that children be released from custody without unnecessary delay, and that children be held in the least restrictive setting appropriate to age and special needs. So I hope that there may be an improvement here, but the overall trend and tendency of the legislation, I believe, is still punitive. With that, I yield back.
Yeah, doesn't fix it. No.
Okay, the question is on the Lofgren Amendment as amended by the King Amendment. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
The chair, the ayes have it.
I'd ask for a recorded vote, Mr. Chairman.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes aye. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes yes. Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes yes. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Johnson votes aye. Mr. Biggs. Mr. Biggs votes aye. Mr. Conyers. Mr. Nadler. Ms. Lofgren. Ms. Lofgren votes no. Ms. Jackson Lee. Ms. Jackson Lee votes no. Mr. Cohen. Mr. Cohen votes no. Mr. Johnson of Georgia. Mr. Johnson votes no. Mr. Deutsch. Mr. Gutierrez. Mr. Gutierrez votes no. Ms. Bass. Mr. Richmond. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu. Mr. Liu votes no. Mr. Raskin. Mr. Raskin votes no. Ms. Jayapal. Ms. Jayapal votes no. Mr. Schneider. Mr. Schneider votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes yes.
Gentleman from Idaho.
Mr. Labrador votes yes.
Has every member voted who wishes to vote? The gentlewoman from Alabama.
Ms. Roby votes yes.
The clerk will report. Oh, we have to let the gentleman from Utah vote.
Mr. Chaffetz votes aye.
We thank the gentleman for his presence. The clerk will report.
Mr. Chairman, 14 members voted aye, 11 members voted no.
And the amendment is agreed to. Are there further amendments? For what purpose does the gentlewoman from Texas seek recognition? Clerk will report the amendment. If there's no amendment, we should go on to another amendment.
No, there is an amendment. I don't know what it is.
Amendment to H.R. 2431 offered by Ms. Jackson Lee. Strike Section 103.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes on her amendment.
The amendment is being distributed, explains this opportunity to explain my amendment, which strikes Section 103 of the bill, a particularly onerous part of H.R. 2431, which uses a jackhammer for a nail. My amendment strikes and changes the title of the bill to Trump's Mass Deportation Act. If enacted, Section 103 would, for the first time in our history, make it a criminal offense for an individual to be present in the U.S. without permission. The short title of this bill should be amended to better reflect its true aim, Trump Mass Deportation Act. At least that is what many people are saying. And what other name should you call a bill that delights in penalizing those who may have moved and not received timely notice of a removal order by adding them to the National Criminal Information Center, the FBI's electronic clearinghouse of crime data that can be tapped into by virtually every criminal justice agency nationwide, 24 hours a day, 365 days a year. As a ranking member of the Crime Subcommittee, I'm deeply troubled by this provision. Moreover, this bill in Section 103 represents a step backwards and stand in stark contrast to the principles and policies of this committee's Overcriminalization Task Force. H.R. 2431 takes a deportation-only approach to immigration reform that will have far-reaching negative consequences. Like a bad episode of The Walking Dead, H.R. 2431 attempts to resurrect the discredited SAFE Act from the 113th Congress and the Michael Davis Act from the 114th Congress. The Trump Mass Deportation Act would take us backward to deportation-only approach that radically departs from current existing immigration law by criminalizing unlawful presence and permitting the prosecution and incarceration of every undocumented individual at immense cost to taxpayers. That means it would impact victims who have experienced, been a victim of crime. It could impact children. It could impact DACA-eligible individuals. It could possibly impact those seeking asylum. Everyone can be caught up in the entrapment of confusion as an immigrant and undocumented in what their process is. It could be deport someone on the way to court, deport someone who has turned themselves in on their regular visits to the ICE office, and instead of being treated with the respect of that they have reported, they are immediately handcuffed in front of their 2-year-old daughter and their wife, and within 2 days deported. The Trump Mass Deportation Act would dramatically change our country's immigration policy overnight, causing the arrest, criminal prosecution of mothers and fathers, tearing apart families of the 4.5 million or more citizens who are minor children. This was the very approach adopted in the notorious H.R. 4437 that sparked massive nationwide outrage and prompted nonviolent protests in 2005. Where is President Ronald Reagan now? Where is the Republicans' Ronald Reagan? Nowhere. This is a mass deportation named by the person who feigns to act like they care about anyone. This was the very approach adopted, as I indicated already. You may recall, Mr. Chairman, that the leaders of the Catholic Church led the backlash to the Republican SAFE Act, asking priests and parishioners to engage in civil disobedience if it became law. And what ensued was a series of peaceful but massive and historic demonstrations when immigrants, labor unions, congregations, and allies by the millions filled America's streets peacefully. Ironically, H.R. 4437 led to an unprecedented wave of citizenship and voting among Latino and other pro-immigrant voters who were energized to fight Republican anti-immigrant policy. The history will repeat itself if the Trump Mass Deportation Act were to become law. I urge my colleagues to support the Jackson-Lee Amendment, which strikes Section 103.
Thank you, Ms. Jackson-Lee.
I yield back.
Recognize myself in opposition to the amendment. I oppose this amendment, which effectively undermines communication, coordination, and collaboration between law enforcement and the enforcement of immigration laws. Specifically, this amendment seeks to strike provisions in the bill that require that the immigration violators file, already a part of the National Criminal Identification Center database, include information that identifies aliens who have been ordered, removed, and who have overstayed their visas. Currently, this portion of NCIC already contains records on criminal aliens whom immigration authorities have deported and aliens with outstanding administrative warrants of removal. Including this information in NCIC is crucial in allowing state and local law enforcement officers to assist in the enforcement of our immigration laws. With more than 800,000 fugitives ordered removed, yet still on the streets in the United States, why would we not want to enable state and local law enforcement officials to identify and apprehend them? In addition, information relating to the large percentage of visa overstays that are still living in the country could be equally as valuable to law enforcement. Surely, if this information had been inputted into NCIC back in 2001, local and state police who stopped 4 men for minor traffic infractions might have been able to apprehend them prior to September 11th. If we want state and local assistance to be effective in enforcing our immigration laws, these agencies need this information, and they need it inputted into the database on which they already rely. So I urge my colleagues to oppose this amendment. Are there other members who wish to be recognized in yes, the gentleman is recognized.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
I'll yield to the gentlelady from Texas.
I thank the gentleman. The very point that you're making, Mr. Chairman, can be easily rebutted. It does not make us safe. Hacking the database, flooding the NCIC database with civil immigration violations would make it more difficult for law enforcement to do their jobs. This amendment would add literally millions of non-criminal records to the NCIC database. As a result, local law enforcement officers using this system would have to waste precious time deciding whether a hit in the system merited action. Local police on the NCIC to determine whether an individual that they have pulled over or detained is wanted on serious criminal charges by another jurisdiction, including the federal government, of which they don't have the ability to ascertain by their own resources. We're going to flood that system. It probably will collapse. Law enforcement does not want this non-criminal information in the NCI. Local law enforcement leaders have opposed efforts to expand the NCIC to include non-criminal immigration information because it undermines the quick, precise ability to research and save lives. While they're going through millions of nonviolent names, someone could be escaping across the borders of other states. It undermines the central purpose of the system to serve as a notice for criminal matters and warrants. I ask my colleagues to do the common sense thing and to support the Jackson Lee Amendment. With that, I yield back.
The gentleman from Georgia yields back.
I will yield back.
Okay, the gentleman yields back. Are there any other members who wish to be recognized? Yes. Mr. Gutierrez is recognized.
Thank you very much, Mr. Chairman. Well, first of all, I thank Congresswoman Jackson Lee for making this amendment. And I'm not going to take up the 5 minutes. I'm going to make one point. Police officers need this database. They need to, they pull over people. They show up at people's homes. You want both for the safety of the people that they're intervening with, that they know who they are and whether they're violent criminals out on warrants or the criminality of the person that they're. You want to protect the cop too. You want to protect the police officer too. You want to give them good information. I understand the majority wants to put this in there so that all the police can become immigration agents, because your purpose is get everybody in the United States and give this to the police. But I think the young lady from Texas probably agreed there are going to be police departments that aren't going to use the information for that.
They can't.
Because their police chief said, that's not the way I want you to police. So even if you give the information, let me just say to the majority, the cops that want to deport people are going to deport them and find the information regardless whether it's on this database. They're going to do it. And the ones that aren't going to do it anyways. So really, it's kind of futile what you're doing. What you are doing is putting the police officers and the public at risk by putting information which isn't germane and doesn't lead to the safety of the citizenship and the police officers. So I think that it's unnecessary data that really is going to harm the policemen and really going to harm the public. So let's take the information out. And lastly, the police officer that wants the immigration information, there's another database. He's going to access it. So there is already access for what you want that police officer to get. But let him at least distinguish whether he thinks somebody's driving because they're here undocumented or whether they're driving away from a bank robbery. I mean, some cops are going to do both things. Some are not going to do both things. So it just seems futile. You're putting policemen at danger and public safety at danger by putting this information in there only to get your goal of let's get all those immigrants. Thank you, and I return the balance of my time.
Okay. Thank you, Ms. Gutierrez. The question is on the Jackson Lee Amendment. All in favor say aye. Aye. All opposed, nay. Opinion of the chair, the nays have it, and a roll call has been requested, and the clerk will call the roll.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith?
No.
Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? No. Mr. Chaffetz votes no. Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes yes. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Are there other members who wish to vote? The gentleman from Pennsylvania,
Mr. Marino votes no.
gentleman from Texas, Mr. Ratliff. Has the gentleman from Texas voted? Oh, has he? Okay, pardon me. Gentleman from Ohio,
Mr. Shabbat votes no.
gentleman, how has the gentleman voted?
Mr. Gates votes no.
Clerk will report.
Mr. Chairman, 8 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there any other?
Chairman, I have an amendment at the desk. It is number 8, the next one. Thank you.
The clerk will read the amendment.
Amendment to H.R. 2431 offered by Ms. Jackson Lee of Texas. Page 184, after line 3, add
Without
the
objection,
following.
the amendment will be considered as read, and the gentlewoman from Texas is recognized to explain her amendment.
Thank you for the opportunity, Mr. Chairman. Aliens in expedited removal proceedings are subject to mandatory detention. This expansion of expedited removal proceedings in tandem with mandatory detention is a recipe for disaster. DHS is not able to provide detention facilities to hold all of the aliens that may be subject to mandatory detention. And might I just offer to my colleagues, the report questions immigration detention, deaths in Houston and nationwide. I'll be joining my colleagues, members of the immigration advocacy community, picketing outside of our detention center because people have died unnecessarily. I ask unanimous consent to submit this report into the record. Unanimous consent to submit this report into the record. Unanimous consent to this report in the record regarding those who have died in detention centers.
Without objection, that will be
Thank you,
made a part of
including
the
that
record.
one in Houston. My amendment provides guidelines and authority for a program of secure alternative to detention that would implement this provision. It provides for a range of humane and cost-effective alternatives to prison facilities that would still ensure an alien's appearance before immigration officials for their removal. The secure alternatives will be based on the best practices utilized by the Appearance Assistance Program. It would address the need to provide non-penal facilities for members of vulnerable populations needing specialized care, such as families arrested with their children, or aliens with serious medical or mental health needs, because that is what happened to these individuals that died. One of them was from Canada. Aliens who are mentally retarded or autistic, elderly aliens over the age of 65, and victims of trafficking or criminal operations. Under current department policy, family units are split up and sent to different facilities with parents separated from their children. Consider the plight of Malik Jarno, a mentally retarded orphan from Guinea, who languished for 3 years in adult jails with violent convicts until more than 70 members of Congress from both parties succeeded in convincing the department to release him to a refugee shelter as an alternative to detention. No child should have to experience such frightening circumstances. This program would be implemented by non-governmental organizations in order to achieve cost savings for the department, and alien selection for the program would be entirely within the direction of the department, and it would not convey any rights or benefits under the Immigration and Nationality Act. Is there any humaneness? I beg of you to realize what is happening in detention centers across America, right in my hometown, in the 18th Congressional District. I am both speechless, outraged, and as a mother and as a human being, I don't believe if you're there on a civil matter in a detention center that you should die. I ask my colleagues to support the Jackson Lee Amendment. I yield back.
Thank you, Ms. Jackson Lee. The gentleman from Idaho, Mr. Labrador, is recognized in opposition to the amendment.
I must oppose this amendment.
The gentleman is recognized for 5 minutes.
Okay. Congressman Smith created the expedited removal process in the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, IRA, because thousands of aliens were showing up at our international airports with false documents or no documents at all because they had flushed them down airplane toilets. These aliens were released and many never heard from again. By the mid-1990s, tens of thousands of aliens were arriving at U.S. airports each year without valid documents, often making meritless asylum claims, knowing that they would be released into the community pending asylum hearings before immigration judges because of a lack of detention space. Few were ever heard from again. As soon as detention facilities were bolstered at one airport, such passengers would switch to another one. In response, the 1996 Act created the mechanism of expedited removal. Under expedited removal, a Customs and Border Inspection officer at an airport can immediately return an alien lacking proper documents to his or her country of origin unless the alien can establish a credible fear of persecution. If credible fear is shown, then the alien will be able to make his or her case before an immigration judge at a later time. After the creation of expedited removal, our airports were no longer being deluged. The expedited removal program, in addition to removing the illegal aliens directly affected, also provides a strong disincentive to other would-be illegal aliens in all parts of the world. Under this amendment, our airports would again be full and aliens would again be released by the thousands. Aliens placed in expedited removal should be immediately returned on the next outbound flight or detained if necessary, but never should they be released into our communities. In addition, many of the aliens subject to expedited removal have serious convictions rendering them aggravated felons or criminal aliens not entitled to release if they were placed in removal proceedings. It would be contrary to the intent of Congress to allow them to simply phone in once a week or wear ankle bracelets, which are all too often cut off and disposed of on highway shoulders. I urge my colleagues to oppose this amendment. Also would like to point out that the last section of the bill, section 603, includes a GAO study of the deaths in custody, which was actually something that Ms. Jackson Lee suggested at the previous hearing on this bill. And I yield back my time.
Thank you, Mr. Labrador. Are there any other members who wish to be heard on this amendment? If not, the vote is on the Jackson Lee amendment. All in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it, and the amendment is not agreed to. Are there any further amendments? If not, and is a reporting quorum present? Oh, the gentleman from Georgia, Mr. Johnson, is recognized.
I have an amendment at the desk.
Clerk will report the amendment. Read the amendment.
Amendment to H.R. 2431 offered by Mr. Johnson. Page 183, line 3, strike by adding
Without
at the
objection, the
end.
amendment will be considered as read, and the gentleman from Georgia is recognized to explain his amendment.
Thank you, Mr. Chairman. I'd like to offer this amendment, which I will co-lead with Mr. Cecilini. And specifically, this amendment relates to Title V of the bill. Before I delve into my objections, I'd like to make sure that the contents are known of this bill. Contents of this bill are known. In one fell swoop, Title V of this legislation would create the Bannon-Trump Deportation Force. The Bannon-Trump Deportation Force would make ICE 3 times larger than it is now. If this legislation were to pass, it would arm the Bannon-Trump Deportation Force with military-grade weaponry to use while conducting immigration raids on unsuspecting individuals and the communities within which they live. This legislation would empower a Bannon-Trump deportation force to remove people from their homes and their families and detain them until they are deported. And the detention would often be under extreme conditions. This legislation would also empower immigration officials to unilaterally revoke the immigration status of individuals without prior notice or due process. This legislation would unleash forces of terror to menace and terrorize neighborhoods, leaving parents, women, children, and the elderly to exist in a permanent state of fear. I urge my colleagues to support this amendment which abolishes Title V. And with that, I would now like to yield the balance of my time to the gentleman from Rhode Island.
Thank you, and I'm pleased to offer this amendment with my friend and colleague, Congressman Johnson. This amendment would strike provisions of H.R. 2431 requiring that every ICE officer on duty is issued body armor and weapons, including handguns, M4 assault rifles, and tasers. This amendment also strikes a provision that deportation officers be allowed to undergo training on enhanced tactical capabilities. The Trump administration has ramped up federal immigration enforcement, with ICE agents conducting highly visible and aggressive raids. ICE agents have gone so far as to target immigrant parents that are dropping their children off at school and even apprehending immigrant women who are trying to report domestic abuse to law enforcement. ICE's frightening new presence around the country has inflicted nothing short of terror in immigrant communities, with parents afraid to go to work and children afraid to go to school. Apparently, this isn't enough for some of my colleagues. H.R. 2431 would dangerously expand ICE agents' enforcement authority even more by arming agents with military-grade equipment. This bill comes after recent comments by President Trump celebrating 2 weeks of ICE raids in February that resulted in the arrest of 683 immigrants as a successful, quote, military operation, end quote. I strongly believe that a militarized immigration force will make our communities much less safe in several ways. For example, all law enforcement agencies rely on people in the communities they work in to cooperate in solving and deterring crimes. However, as immigrants are being increasingly forced into the shadows by this administration's oppressive immigration regime, they have become frightened to report crimes and testify in court for fear of being apprehended by ICE. Undermining this critical relationship between immigrant community members and law enforcement has made victims afraid to come forward and allows perpetrators of crime to escape prosecution. Proposals that weaken community trust are especially dangerous for victims of sexual assault, domestic violence, and trafficking. In addition, H.R. 2431 would potentially put military-style weapons, such as M40 assault rifles, in the hands of every ICE agent. The M4 is best known as a military combat weapon used in the U.S. Armed Forces. It's hard to believe that every ICE agent has or would receive the crucial training necessary to operate a weapon commonly used for combat. Yet this bill could have ICE agents with newfound enforcement powers roaming our streets, our neighborhoods, stores, and our schools with military-grade weapons that they do not properly understand how to use. I'm also concerned this bill encourages ICE agents to rely on the threat and use of deadly force instead of methods used to de-escalate conflict. This is especially concerning because a confrontation may ensue in any situation where a person is targeted for deportation or immigration detention. In a situation where agents target busy public places for immigration raids, such as a mall or a restaurant, widespread fear and panic during the raid could heighten violent or lethal force used by agents that have disproportionately powerful weapons. For these reasons, I urge my colleagues to adopt this amendment, which will remove an extremely harmful provision of H.R. 2431 that would give new and potentially deadly powers to immigration officers. And with it, I yield back the 1 second I had.
Gentleman's time has expired, and the gentleman from Idaho, Mr. Labrador, is recognized in opposition to the amendment.
Thank you, Mr. Chairman. I oppose this amendment as it would greatly hamper ICE's ability to carry out its mission safely and would likewise place ICE officers in severe danger. This amendment would strip the provision ensuring that ICE has the weapons necessary to carry out its enforcement actions. I'm a little bit confused why this has suddenly become the focus of so much negative attention, including speculation that this was placed in the bill to promote the Trump administration's agenda. Maybe my friends on the other side of the aisle forgot that this section was part of the bill last year when it was introduced under the Obama administration. I could understand that concern, but for the fact that this language was in that version, and it was a bill that passed in Congress in the 113th and the 114th Congresses. This is not a new provision, and it is certainly not there to appease the administration. It is part of this bill because the safety of ICE officers should matter to all of us. ICE is a federal law enforcement agency. Its mission is different from the FBI, the ATF, or the DEA, to be sure. But that does not mean that ICE officers are exposed to any less danger than these other agencies. I look forward to hearing opposition when this committee looks at the Secret Service authorization bill. Sure, even opponents would be hard-pressed to say Secret Service agents do not need advanced weapon systems. No one's suggesting that ICE officers carry M4s or any other weapons aside from the agency-issued handguns as part of a daily routine or into malls or anything like that. These weapons are simply not meant for day-to-day operations. However, when a high-risk situation develops, We want to ensure that our law enforcement officers, including those at ICE, can protect themselves and the greater community from dangerous criminals who likely have even better weapons at their disposal. In a letter to California Supreme Court Justice Tani Cantil Sakayui, dated March 29, 2017, Secretary Kelly and Attorney General Sessions wrote that due to sanctuary policies, ICE is often charged with locating dangerous individuals on the streets or in public places instead of in the safety of a jail or prison. That's actually the most ironic thing about the other side's argument in this case, is that they're making it less safe for communities by advocating for sanctuary policies. Instead of finding the criminal aliens in the jails, ICE now has to go to homes and other areas to find the criminal aliens. When a criminal alien is released and knows that ICE may be looking for them, that person is likely to put up a fight, and it's the duty of this Congress to ensure that ICE comes to that fight prepared. This certainly is not a novel concept. Just recently, it was reported that 3 aldermen in Chicago were proposing legislation to provide training to Chicago police in order to put more long guns in their hands. I am not going to suggest that ICE's mission is any less important, any less dangerous than any other law enforcement officer. When these weapons are needed, they should be available. Further, the bill clarifies exactly what law enforcement actions a deportation officer may take without a warrant. With the exception of an amendment as to their arrest powers, this is nothing new, and deportation officers have always had this authority. The importance of this provision is to clarify that deportation officers, in fact, do have this authority, since no agent or officer with U.S. Immigration and Customs Enforcement is explicitly mentioned in the Immigration and Nationality Act. Since ICE itself has never been codified, it is crucial that in doing so, this Congress takes the steps to ensure that the officers on the front line know exactly what their authority is and how they may perform their law enforcement duties. While it may not change the manner in which the deportation officers do their jobs, it will for the first time provide them with the specific authority, statutory authority. I also asked for the letter from Secretary Kelly and Attorney General Sessions to be put into the record.
Without objection, the letter will be made a part of the record.
Thank you, and I yield back.
Thank you, Mr. Laboratory. Does any other member wish to be recognized on the Johnson Amendment? If not, the vote is on the Johnson Amendment. All in favor, say aye.
Aye.
Opposed, nay. Opposed, nay.
I'll ask for a recorded vote.
Okay. In any case, recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith?
No.
Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomer? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes nay. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Yes.
Mr. Conyers votes yes. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes yes. Mr. Deutsch? Mr. Gutierrez? Yes. Mr. Gutierrez votes yes. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes yes. Mr. Raskin? Mr. Raskin votes yes. Mr. Ipaul? Mr. Ipaul votes yes. Mr. Schneider? Mr. Schneider votes yes. Mr. Marino votes no.
The gentleman from Georgia, Mr. Collins?
Mr.
Votes
Collins
no. A
votes
gentleman from Idaho? Mr. Labrador votes
Labrador
no.
votes no.
Gentleman from Florida? Gentleman
Mr.
from
Gates
Louisiana?
votes no.
Gentleman from Louisiana? The gentleman from Texas, on my left.
No.
Mr.
Votes
Gomer
no.
votes no.
The gentleman from Rhode Island.
Mr. Cicilline votes aye.
The gentleman from Virginia.
Mr. Goodlatte votes no.
Any other members who wish to cast or change their vote? Then the clerk shall report.
Mr. Chairman, 8 members voted aye, 17 members voted no.
The clerk has reported, and the gentleman, Mr. Johnson's amendment is defeated.
Thank you, Mr. Chairman. I have another amendment at the desk.
The gentleman from Georgia is recognized for, the clerk will report the amendment.
Amendment to H.R. 2431 offered by Mr. Johnson. Page 183, line 3, strike by adding at the end and insert the following.
The gentleman from Georgia is recognized for his amendment.
I'd ask that the amendment be considered as read.
The amendment is considered as read without objection, and the gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise to offer this amendment, which would guarantee individuals who are facing the Trump deportation force, it would guarantee that they have a right to counsel. This bill, Mr. Chairman, criminalizes being unlawfully present in this country. If one overstays a visa by 1 day or even 1 minute, or if the terms of a person's entry are violated in any way, including a technical or an insignificant violation, then that person faces criminal charges. This bill converts undocumented individuals into criminals. In America, any person charged with a crime has a right to counsel. We should pass this amendment, which will guarantee that detainees caught up in the dragnet that this legislation creates will have a right to counsel. And if they cannot afford one, one should be appointed to represent them. This is the only way to ensure that detainees, some of whom face death upon return to their home countries, receive due process under the law. Mr. Chairman, 11 million people are thought to be undocumented in this country. When this legislation, or should this legislation pass, those 11 million people will become suspected criminals. If this legislation is signed into law, deportation and removal will no longer be purely an administrative process. It will become a criminal process, and so therefore the protections of the criminal law should ensue. The most important one of which is the right to counsel. This legislation deputizes state and local law enforcement agents as ICE agents. It gives them the ability to lock folks up, lock suspects up for having violated the provisions of this legislation. If the police are out hunting down and locking up suspects for ICE, then it's only logical and it's only within our constitutional norms to afford those suspects with the right to counsel, particularly when their very lives are in jeopardy. Due process protects a person, and a person is entitled to due process when their life, liberty, and property interests are affected by the state action. And so this is a common sense amendment that comes along with, is a natural byproduct of passage of this legislation. And so in order for us to adhere to our constitutional norms, which we hold so dear in this country, I'm hopeful that my colleagues on the other side of the aisle will see the common sense and constitutional reasons for affording people, 11 million of them, who become criminals upon passage of this legislation, to afford those people with the right to counsel, which the courts will probably find. So that is my argument, and with that, I will yield back.
Gentleman returns this time. For what purpose does the gentleman from Idaho seek to be recognized?
Mr. Chairman, I oppose this amendment. I'm going to be really brief. The Supreme Court has already...
Gentleman's recognized.
Thank you. The Supreme Court has already indicated that there is no right to counsel in immigration proceedings. And if there is a criminal charge, there's already a right to counsel in those proceedings. So this amendment is not common sense. In fact, it's illogical and it's unnecessary. If you are just in the removal proceedings, there is no right to counsel. The Supreme Court has sustained that and upheld it for many, many years. And if anybody is charged for a new crime under this statute, they will be afforded the right to counsel that our Supreme Court and our Constitution guarantees. And for that, I object. I will not. We have to go vote. So with that, I yield back.
The gentleman from Idaho returns his time. The question is on the amendment. All those in favor shall say aye. Aye. All those opposed, no. No. In opinion of the chair, the noes have it. The noes do have it. The amendment is
I
defeated.
request recorded vote.
The gentleman has requested a recorded vote. The clerk shall call the vote.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Isa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? No. Mr. DeSantis votes no. Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? No. Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? No. Mr. Biggs votes no. Mr. Conyers? Aye. Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Anyone care to cast or change a vote? Gentleman from Virginia?
Mr. Goodlatte votes no.
Gentleman from Ohio?
Mr. Shabbat votes no.
Gentleman from Pennsylvania?
Mr. Marino votes
Gentleman from Texas?
no. Mr. Farenthold votes
Gentleman from Rhode Island?
no. Mr. Cicilline votes aye.
Anyone else care to cast or change your vote? The gentleman from Texas?
Mr. Gomert votes no.
Anyone else care to cast or change your vote? Hearing none, the clerk will report. Okay.
Mr. Chairman, 8 members voted aye, 16 members voted no.
8 members voted aye, 16 members voted no. The Johnson Amendment has failed. The committee will now recess until for votes, and we shall return immediately after votes.
Eric? Thank you, sir. Are we ready? Let's do it. The Judiciary Committee will reconvene. When the committee recessed for the last vote series, we were considering amendments to H.R. 2431. Are there further amendments to H.R. 2431?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 2431 offered by Mr. Gutierrez. Add at the end of the bill the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you so much, Mr. Chairman. My amendment would allow U.S. citizens who are detained by ICE, CBP, or by a local police or sheriff's department on suspicion of being an immigrant in the U.S. illegally to sue the U.S. government or the state or local authority who took action on behalf of the federal government. My interest in this stems from the fact that I'm Puerto Rican, born in the United States, to parents who were born in Puerto Rico, who were also born in the United States. So I can go all the way to my grandfather, citizen, my parents citizen, I'm a citizen, my children a citizen. But they never stopped anyone from telling my parents or telling me that I should just go back to Mexico. It's never stopped anyone. Just yesterday, Mr. Chairman, on Twitter, Christy, who describes herself as a mother and grandmother from California, told me, quote, "Leave our country, go back to Mexico where you belong." So I can tell you from personal experience that a lot of the anti-Mexican comments that are thrown around these days are really a shorthand for ways of saying Latino. When Donald Trump descended the golden escalators at Trump Tower and said in announcing his presidential campaign that Mexicans are rapists and drug dealers, and regardless of whatever subgroup of Latinos he may have meant to denigrate and slander, what Latinos heard was aimed at not just the quote-unquote Mexicans, but all Latinos in the United States of America. Any Latino, or frankly, any person of color in this country can tell you that racial profiling is prevalent in our country, and furthermore, that racial profiling is often inaccurate. Americans are just not very good at determining someone else's ethnicity. Ask 3 people what race Dwayne "The Rock" Johnson is, and you'll get 3 different answers. And he said it when he announced his bid for the White House with his running mate Tom Hanks on Saturday Night Live the other day. It's even harder to look at someone and determine the complicated legal matter of whether someone is in full or complete compliance with immigration law. If all Latinos are Mexican and all Mexicans are murderers, rapists, killers, and drug dealers, it can get pretty harsh for the Latino community in the United States of America. Some Republican members of the House of Representatives say that you can tell who is undocumented. This is an actual quote, Mr. Chairman. Republican members of the House have said they can tell who's undocumented by looking at someone's shoes. As one of our Republican colleagues argued on national TV, saying shoes were sufficient to identify immigrants and specifically their immigration status, that they were here illegally in this country. Now, racial profiling is a problem for several reasons, including that Americans do it a lot, and Americans don't do it very well. But most importantly, it's just bad law enforcement. Racial profiling does not yield the law enforcement results that we need our law enforcement to achieve in order to keep our schools, our neighborhoods, and our country safe. We tend to waste resources looking at classes of people who are not significant threats and who do not focus enough our resources on people who pose actual significant threats. So as lawmaker, our legislation should be to disincentivize racial profiling whenever possible, and my amendment seeks to do that. We all saw the viral video over the weekend of a transit cop in Minnesota asking a writer for his papers, asking him if he was in the country illegally or not. It was captured on tape by a bystander who had the good sense to see what was happening, take out his phone, record the incident, even challenge the police officer of whether it was right or his response to question a subway rider about his or her immigration status. And frankly, based on the clip I saw, the police officer backed off real quickly. But that was not the case for Eduardo Caraballo, who was arrested for petty crime and sent to Cook County Jail in Chicago. where he would have been booked and released. But the sheriff's office received a detainer request on Caraballo as a suspected undocumented immigrant and didn't release him and kept him in jail for several days based on the detainer. As it turns out, Mr. Caraballo is Puerto Rican. Always has been, always will be. Was an American citizen, his parents were American citizens. Judging from his rap sheet, he was no saint, but he was an American citizen and still is. My office called the Cook County Sheriff's Department and told them they did not have to honor the detainer on any other Puerto Rican, and we worked with them to understand that in the absence of a warrant issued by a judge, the Sheriff's Department did not have to hold anyone for a federal government on an ICE detainer, which is the genesis of this updated and effective policy we have in Cook County. But it's not just Puerto Ricans who are incarcerated on suspicion of being here illegally. Hector Veloz is a U.S. citizen and Vietnam veteran who was held for 13 months in detention so he could prove from behind bars his citizenship. I'm told there are a lot of other cases of people detained, spending days in jail like Mr. Caraballo, a few months in jail like Mr. Veloz. I want our laws to create a severe financial disincentive to that happening again, and again. So I would like to be clear that if our Department of Homeland Security wants people held and wants private companies and state and local governments to do that holding, and frankly, that has a lot to do with failed and demonstrably ineffective practices of racial profiling, that there will be consequences, is what I want U.S. citizens that are held illegally. Thank you, Mr. Chairman.
Chair thanks the gentleman, recognizes himself in opposition to the amendment. The amendment certainly serves some good purposes. However, it is fraught with some difficulties. First of all, the language notwithstanding any other provision of law is not clear to me and others as to what other provision of the law you may be driving at. Secondly, the knowingly standard is not contained here, and it's perfectly appropriate for law enforcement at any level to detain someone, and if they are improperly detaining them, there are protections under Section 1983 of our U.S. Code, but without the protection for law enforcement at any level to use, without the use of the word knowingly, that's a problem. Furthermore, the private right of action already exists, but I'm not sure that the federal government can bestow a private right of action against a state or local law enforcement officer. So for those reasons, I must oppose the amendment, and I'm happy to recognize the gentleman from Idaho.
I just have a quick comment. As the son of two Puerto Ricans and a Puerto Rican myself, I have been told by many liberals in Idaho, especially recently when I announced that I was running for governor, that I need to go back to my home country. So I don't think that it happens on just one side of the aisle, and I think mistakes happen and people are ignorant sometimes on both sides of the aisle. So I don't think, I just wanted to make that comment and I yield back.
And yield to me for...
I'd be happy to yield to the gentleman.
Oh, thank you so much. Perfect point that the gentleman from Idaho makes. I mean, if I were to think of somebody and see somebody that was Mormon, conservative, from Utah, the last thing I would think is Puerto Rican. Idaho, sorry. Last thing I would think is Puerto Rican, right? And last thing I would think, right? But indeed you are, right? That's the bad stuff about racial profiling. It's usually wrong and doesn't serve a good public purpose. So my goal, Mr. Chairman, was to say, God, people are held in detention based on racial profiling. Racial profiling. And the other point I want to make, look, in America today, I wish my colleagues could come to my office one day and hear the phone calls that we get from people saying, send them back to Mexico, referring to me. And on Twitter, all Latinos now are looked at in a suspicious manner, and I think a lot of police officers are going to take that and violate people's rights. So that's my only point, to stop racial profiling and to disincentivize it. And I thank the chairman for
Reclaiming
allowing
my
me.
time, I appreciate the gentleman's concern, and we would all be concerned about racial profiling. The problem here is that the rule of construction you put forward goes beyond that, and someone could very unknowingly and accidentally and in good faith detain somebody who is a United States citizen and should not be prohibited from doing so if they are in a legitimate way attempting to determine the status of an individual and have some other reason to believe that they might not be a United States citizen. So while I appreciate the goal of the gentleman and his amendment, I cannot support the amendment as drafted.
Mr. Chairman.
For the purpose of the gentleman from California, seek recognition.
Mr. Chairman, I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
I think that the gentleman's amendment should be supported. And here's the reason why. We found that under 287G, which purported to provide training to local law enforcement, even in those instances where training was provided, mistakes were made. Not only that, ICE agents have made serious mistakes, and they're supposed to be experts on immigration law. And I'll just give you, the Cato Institute, as I mentioned earlier and put into the record, did an analysis of this bill, and I thought that their data was really very pertinent. They noted a couple of instances, just for example, the Allentown and Lehigh County, Pennsylvania cases, where a U.S. citizen was wrongfully detained as an unauthorized immigrant. The Clackamas County, Oregon, they settled a case after they detained an American citizen for 14 days based on an ICE request. For 2 weeks in jail is not an innocent mistake, a brief stop. Utah settled a case where they detained an American citizen for a month and a half at the request of ICE. And a U.S. citizen in Rhode Island was wrongfully detained by state police, not once but twice, at the request of ICE. Now, it's interesting that there was a lawsuit in Rhode Island, and Rhode Island is not exactly the most immigrant prevalent state in the Union, but ICE issued detainers for 462 people who state police found out later were American citizens. And that is about 10% of all the detainers that ICE issued and asked for were American citizens. So the point of civil lawsuits is to deter wrongful behavior. And if there is no disincentive for agents to hold Americans in jail because of allegations they're immigrants, we will see more of it. Whether it is racial profiling, and it very well might be, or just sloppiness, who knows? But it is absolutely wrong for an American citizen to be held in jail for immigration violations when an American citizen can't violate their immigration status. They're an American. So I commend Mr. Gutierrez for his amendment, and I intend to vote aye. And I would yield.
Thank you so much. Mr. Chairman, see, this is really not an American issue that I'm raising. I know it's an immigration bill. It's an American issue. It's about the right of Americans to be able to walk their streets, go to their homes, go to church. And the chairman has admitted that we are going to expand the dragnet. That's what we're doing. We're making sure that the files where the criminals are, all their records are kept, that we're putting immigration information. We want the local police to do things. What you are doing is inevitably going to harm people because you're expanding the dragnet. Lastly, let me just suggest to the chairman the following. We should, I would hope the chairman, instead of saying, oh, you're flawed, Mr. Gutierrez, would say, hey, you know, I'd like to stop that too, Mr. Gutierrez, because I want to stand up for American civil rights and their rights to walk and not to be interfered with, and for the Constitution to be protected, that when I come in contact with a police officer, they have reasonable and just cause to interact with me, not their suspicion on my immigration status. Lastly, 1996, it's well publicized. I came into the Congress one day to come and vote. I was held by a Capitol police officer and denied entry. You know what the last word she said when the sergeant took her away from her position? She said to me, if he and his would just go back where they came from. You know how many times I've heard go back where you came from in my life? Many times. But I got it said by a Capitol Hill police officer. And I just want for the record to know that I asked the head of the Capitol Hill Police not to fire her because I felt that she was responding to ugly, negative political rhetoric in this Congress of the United States, and that she should somehow be allowed to come back again. And she did come back as a Capitol Hill police officer, and she and I became the best of friends. But it happened. So I'm not out here to punish people. I'm out here to protect Americans.
Time of the gentlewoman has expired.
Move to strike the last word.
The gentleman from Maryland is recognized for 5 minutes.
Mr. Chairman, thank you very much. I rise in very strong support of Mr. Gutierrez's amendment to the legislation, and I hope that everybody in this debate, on all sides, whether you consider yourself the most pro-immigrant person in the country or the most anti-immigrant person in the country, everyone will read this amendment and concur that we need to pass it. All it says is that Section 102 of this act may not be construed to authorize any officer or employee of the United States or of any state or political subdivision to detain or conduct a search of a citizen of the United States. Now, that's something that should be embraced by everybody across the country and have it backed up by the ability to sue. One would think that people on the furthest reaches of the left and the furthest reaches of the right would agree that the federal government should not use the pretext of immigration authority to be going after the rights of citizens and to be detaining citizens. And of course, that's been the history in the country. Whether you're talking about the Palmer raids or you're talking about the incarceration and detention of Japanese American citizens. Originally, it started with going after Japanese foreign nationals, and then they went after citizens. But this could be a huge Leviathan bureaucracy that goes after the rights of every citizen of the United States. So I would hope that everybody on this panel in the Judiciary Committee would agree that nothing in this legislation can be used to detain or conduct a search of a citizen of the United States under the immigration authority of Congress. And of course, you've got the right to appropriate relief if that takes place. We know that under the Bivens decision, the Supreme Court has already said you can bring a private right of action if your due process rights are violated. So, Mr. Chairman, I just hope that all of us would be able to agree and we could declare this one unanimously to be part of the legislation. I yield back.
Would the gentleman yield?
By all means.
I thank the gentleman for yielding. First of all, the fact that prior Democratic administrations engaged in mass detention, as the gentleman describes, has been addressed under current law in the Congress already. And this language, which in some cases is surplusage, but in other cases goes beyond that because it doesn't have a knowingly standard, is not the same as the current law. So I strongly disagree with the gentleman that this language is simply confirming existing law. It goes beyond it. It would make it more difficult for law enforcement at every level of government to enforce the law. And for that reason, I oppose it.
Mr. Chairman.
First, the gentleman from Rhode Island seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I rise in strong support of Mr. Gutierrez's amendment. I would first say at the outset, I am disappointed that we can't seem to muster the same enthusiasm and energy on the other side of the aisle that we saw to detain and deport immigrants to our country, that same level of energy and commitment to protecting the constitutional rights of U.S. citizens. But the amendment offered by Mr. Gutierrez simply says, notwithstanding any other provision of law, Section 102 of this act may not be construed to authorize any officer or employee of the United States or of any state to detain or conduct a search warrant of a citizen of the United States. This legislation purports to convey or authorize a whole bunch of actions by local and state governments that frankly invites them to enact and enforce immigration laws. And it makes perfect sense to say at the same time, understand that nothing, although we're conveying all these rights and inviting you to enact, implement, and enforce criminal penalties that criminalize the same conduct, that it may not be construed in any way to authorize the detention or search of a citizen of the United States. This is a basic constitutional right. It ought to be explicitly stated in a statute that broadly expands the category of crimes to status crimes, reduces the level of due process in a number of ways, accelerates the deportation proceedings. Does it make sense in that to say, oh, and by the way, you're not authorized to search or improperly detain citizens of the United States? I remember a day when Republicans would stand up proudly and defend such a suggestion. Secondly, the private right of action is to be sure that this right can be protected and can be enforced. And with respect to the suggestion that somehow we're conferring a cause of action on states, that's simply not the case. It says any United States citizen who's detained pursuant to Section 102 may bring an action for appropriate relief in a court of competent jurisdiction. There are lots of case law, much case law that will decide what is an appropriate court, where jurisdiction is proper. Those rules will apply. So the notion that somehow Mr. Gutierrez is creating some state cause of action is not true on the face of the amendment. This would be a welcome addition to a very bad bill that I think does gross violence to our founding principles, but that at least save this one kernel of protection for American citizens to say, if in the sweep of all of this, you're improperly searched or detained, you have a right to seek a remedy and to seek relief and seek compensation for that. I applaud the amendment of Mr. Gutierrez, and I have a little time remaining.
Mr. Chairman.
First gentleman from Michigan, seek recognition.
To support
Gentleman's recognized
this
for 5 minutes.
amendment, without the Gutierrez amendment, we're saying that it's okay for law enforcement to stop Americans, American citizens, and demand they show their papers. It's as simple as that. And I'm sure if you approach it from this perspective, you will agree with the Gutierrez amendment.
Would the gentleman yield?
I'll yield to Mr. Raskin.
Just to follow up on the point made by the ranking member there, it seems as if we're now in the business of trying to corner local governments around the country, commandeer their resources, commandeer their personnel, conscript them to a federal battle to participate in enforcement of federal laws, and then we're willing to empower them to sweep in with the ambit of their work U.S. citizens in the process. I mean, one can hardly think of a more direct and honest restatement of basic constitutional principles than the Gutierrez Amendment, where he's simply saying, if you're going to create this huge dragnet to go after alleged undocumented immigrants in the country, don't use it as a power to detain U.S. citizens. And now, without this amendment, which appears to be on the verge of defeat, they're going to empower not just the federal government, but the states and the local governments to interrogate and detain U.S. citizens. So, I mean, I suppose, I can't profess to be that melancholy because the Supreme Court or federal court will strike this down immediately, but it's hard for me to see why we would put unconstitutional graffiti all over the immigration code. I yield to the distinguished gentleman from New York.
No, I have the time.
I'm sorry, yield back.
All right. All we want to do here is get the Gutierrez Amendment into this legislation.
Would the gentleman yield?
Sure.
The gentleman from Michigan yield?
Absolutely.
Section 102 of this bill would allow a state or local government to pass a law to make it a crime to engage in human smuggling of immigrants. This amendment would then say that if that person was a United States citizen, they couldn't be detained. I mean, this is way overbroad, and current law covers the protections that have been demanded on your side of the aisle. So, again, I must oppose the amendment.
I yield to Mr. Gutierrez.
Thank you so much. And I just want to continue the conversation with the chairman of the committee. Look, we're expanding in an unprecedented manner enforcement of immigration policies and we're even taking the database and adding to where there are drug dealers, murderers, rapists, and really bad people, we're adding immigration information. So we're basically telling the police departments across the world, across our nation, treat them all the same. And we're asking local law enforcement. We're going to ask for tens of thousands of additional ICE agents and Border Patrol agents, all to go out to do one thing, what the President of the United States has promised, which is he was going to deport all 11 million of them. So that's the promise. And I want to go back to something that I think is fundamentally important to this legislation. This legislation is an outgrowth, and I thank Mr. Cañas for allowing me this time. It's an outgrowth of what? The president saying Mexicans are murderers, rapists, drug dealers, they're bad people, and we're going to get rid of them. He said that. And then the only people he ever...
Would the gentleman yield?
Sure. That's my turn.
I thank the gentleman for yielding. I just want to make the point that this bill was originally introduced in 2013. It has nothing to do with the outgrowth of the president's comments or what you think his objectives are. This is legitimate legislation passed out of this committee twice before.
Thank you for letting me reclaim my time. But what we're living in right now is President Trump's time. And so it makes this bill even worse at this particular time than any time before. Because what the president has said and what he has inculcated in the minds of Americans, because I want to make sure that you understand that when he says Mexicans, it's understood it's Latinos. Because all Latinos across this country, regardless of their country of origin, understand when he says Mexicans, he means Latinos. And I just want to go back. If we're going to go in an unprecedented manner in this new dragnet, and we know the target is Mexicans because it's the only ones we've talked about, and he appoints the head of Homeland Security, we know where his vision is. I'll end with this, and I thank the chairman for it. Just 2 weeks ago, the Attorney General of the United States stood at the border. Now, the only border he ever thinks anybody illegally comes across is the Mexican border. That's been clearly stated. He said, I want to stop this filth,
Gentleman from Michigan has
from coming. That's how he refers to human beings.
Chairman.
For what purpose the gentleman from New York seek recognition?
Strike last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, first of all, I just want to comment on Mr. Gutierrez's comment. When you say we know the target is Mexicans, at least after the president's speech in Saudi Arabia, we presume it's no longer Muslims. So it's got to be only Mexicans and other Latinos. Mr. Chairman, I support this amendment. And all the amendment does is say that with respect to detaining or conducting a search of an American citizen, the law should remain the same as if Section 102 were not enacted. This does not restrict the ability beyond that. And it should go without saying that you have nobody, no state elected, no state enforcement official, no federal enforcement official has the authority to conduct a search or detain an American citizen unless they have probable cause to believe a crime has been committed, unless they have reasonable suspicion or probable cause to detain that person. We've all seen movies of Europe in the 1930s where someone gets on a train and says, "Papers, please." We've all said to ourselves, or at least many of us have, thank God we don't live in such a society. I don't have to carry my papers when I go to the corner candy store. If I'm driving a car, I have to have my registration, my license, but I'm walking down the street, I don't have to have any papers. And the fact that someone demands papers is wrong. And the fact that someone would detain or conduct a search of an American citizen without probable cause is also wrong and unconstitutional. And all this says is anybody who wants to read Section 102, read it any way you want, but not to do something obviously unconstitutional and wrong so as to detain or conduct a search of a citizen of the United States without a probable legal cause to do so. And the private right of action is a good thing to enforce that. And I presume the private right of action is against the state or local government, not against the individual police officer who is acting within the scope of his employment, unless you can show that he was not acting in good faith. So I think this is an excellent amendment. It puts a proper limit on what some people might read into this bill otherwise. I'm not sure everybody would, but no one should. And we don't want to get to a society where in the name of enforcing immigration laws, people have the right to say, "Your papers, please." and certainly not on a racially or discriminatory basis, which we know is going to happen, and which we know it has happened. He looks foreign, he looks or sounds Mexican or Puerto Rican or whatever. That shouldn't happen in this country. So I commend Mr. Gutierrez for offering this amendment. It seems the least we should do if we're passing this bill, which I hope we're not, but we obviously are going to. So I urge the adoption of this amendment. I yield back.
What does the gentleman from Illinois seek recognition?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you. I rise to speak in favor of this amendment. And as I sit here, I reflect earlier this afternoon, I had the privilege of speaking to a group in honor of Jewish American Heritage Month. This was a group of mostly Orthodox Jews, many of whom dress in traditional garb, dress very differently, look very differently than I do. But in each and every way that I am, they are American citizens. I could have just as easily been speaking to a group of Indo-Americans or Mexican, Latino Americans, all of whom share the rights and privileges of American citizenship, as do I. I support this amendment because it very, very clearly states in support of the right of all Americans to have the constitutional protections of not being arrested by an officer on suspicion of a crime now that it's been defined that being different or being from an outsider is a crime. So it is my honor, and I'm grateful to my colleague from Illinois for introducing this amendment. I will strongly support it. And with that, I'd like to yield my time to Mr. Gutierrez.
Thank you so much. Again, Mr. Chairman, this is not an immigration amendment. This is an American amendment. My amendment specifically goes to protecting the rights of American citizens from being abused by police officers under this legislation. And it's American because the founding fathers wrote it into the Bill of Rights, into our Constitution, that you have to have probable cause. And probable cause cannot be that you look like a Mexican. It cannot be that, because that is racial profiling. It has to be something other than what a police officer determines you to be by the color of your skin, the accent of your voice, or who you are, the texture of your hair. And this is what is going to happen with this unprecedented expansion of police powers into communities. And let's be honest with one another. They're going to come into predominantly Latino communities to come and do the raids. We know from past history. That doesn't mean that other communities won't be impacted. But what I want to do is I want to protect American citizens from being harmed by police officers. A couple of last things, because I think it's important. Just personal. I was on an airplane a couple of weeks ago. I saw this Muslim couple. I was in 2A, and they were being separated, and his wife. And I said to him, Assalamu alaikum, please have your wife sit here and we'll exchange seats. Why did I do that? Because I prefer to be in the first row? Because I figured, given the hostility in America, we should all try, every instance we get, to show that people are welcomed in the United States of America. And just this past Saturday, I saw 3 of Chicago police officers' finest. They took their vests off, their bulletproof vests off. I walked up, I picked up their bill. Why? Because all of a sudden I become a fan of the Chicago Police Department? No, because I wanted to say, look, they knew who I was. They know my ancestry. They can identify, my ethnicity. And I wanted to say, hey, police, we want to have a conversation with you. I want to pick up your bill because I know you go through dangerous times. I want those police officers to treat everybody well, whether they're wearing Muslim garb or they think they're from Mexico or they think they're from any part. And as my friend said, whether they look like they're Jewish and how they dress. You shouldn't be identified by how you dress, how you look, the texture of your hair, the color of your skin, or your national origin. And this is an American amendment that protects Americans against undue police involvement in their life without reasonable cause.
Would the gentleman yield?
Sure, I will.
So, in American history, it seems as if attacks on the rights of aliens then ratchets down the protections afforded to citizens. And I'm cheerful to give examples that have taken place not just in Republican administrations, but in Democratic administrations. So we can talk about the Palmer raids, and we can talk about what happened during World War II with the incarceration and detention, not just of foreign national Japanese individuals, but also Japanese American citizens. Do you think there's reason to believe that if we don't have your amendment, that this is going to endanger the rights of Latino American citizens along with undocumented immigrants?
If we don't adopt, I think adopting this will give further protections to Americans. And yes, to everybody, but to Americans. And what it will do is it will lift that standard that I know Mr. Reskin and I want in America.
Mr. Chairman.
Time of the gentleman has expired. For purpose, the gentleman from Washington seek recognition.
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm not sure why this amendment would be controversial, quite honestly. I want to thank Mr. Gutierrez for offering it. I think it speaks to much of what we've seen, not just now, but over the last 10 years, as we've continued to see people swept up in raids that are U.S. citizens, and many of us have had to advocate on behalf of those individuals time and time and time again. And to me, not only is this amendment common sense, patriotic, but it's also necessary to send a very important message that, as it says here, that nothing in this act should be construed to authorize any officer or employee of the United States to detain or conduct a search of a citizen of the United States. That seems to me to be pretty simple and extremely uncontroversial given everything else we've been talking about today. You know, I'm not sure that you can just say mistakes happen and let that be the record for the day. Our job should be to not allow those mistakes to happen and to offer United States citizens who have been caught up in this, you know, frenzy, what it feels like sometimes is a frenzy of raids for people to just identify anybody based on what they look like. I think we should be offering the opportunity for those mistakes to be rectified. We should be taking them seriously. We should take seriously the concept of citizenship and recognize that if there are mistakes, that we should do everything in our power to prevent them from happening or to afford the opportunity to correct that. It seems to me that that's what this amendment is trying to do. And I would hope that all of my colleagues on both sides of the aisle would actually support this because it is about U.S. citizenship. It is about those who have already been granted the opportunity to stay here or who are born here and have citizenship by right of birth, but it's a protection for the people that we are supposed to protect. So I really don't know what's controversial about it, and I hope that we would all strongly support it, and I want to thank Mr. Gutierrez for offering it. I yield back. Yes, I will yield.
Look, Mr. Chairman, I wish we could spend some time together in my office after, you know, I do Fox News, and you could hear the phone calls that come in to my office. And clearly, everybody that knows me knows my dad's from Puerto Rico. They know how I always stand up for that, my little island and New York City and the Puerto Rican community. But I always get called Mexican. Now, I'm happy and proud to assume to be Mexican. Because that's the way the American public now views stuff. It's a radical change. And that's why I think it's very, very important. And it's really, really ugly out there, Mr. Chairman. Really, really ugly out there. The kind of new, you know, bigotry and prejudice that exists, particularly, and unfortunately directed by the President of the United States because of his commentary. I mean, I have young staffers, Mr. Chairman, that get called the most vile words that I will not repeat here. The most vile words. That's how the conversations end after they say, send them back to Mexico. So look, we live in a different time, in a different moment. And if we're going to expand these police powers and this dragnet, I think it's time to also have different protections and new protections. I thank the gentlelady.
Chairman, I yield back.
For purpose, the gentleman from Iowa seek recognition.
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I've been listening to this debate and this dialogue, and there are a few things that should cap off this discussion before we come to a conclusion on the Gutierrez amendment, which I rise to oppose. And first thing is the characterization of President Trump's statement about the illegal activities of Mexicans. He had a clause in there too, that he said that they were also many good people among that universe he was talking about. But it is a fact that there are many murders, many rapes, and many drug dealers in Mexico and from Mexico. And I thought I should look at some data so this committee would have the record here, and remembered some numbers and went back and looked at this. Some of this is very, very tragic, and we ought to be thinking about the tragedy of the lives that have been lost. From 2007 to 2014, according to a reporter, Jason Breslow, that the total deaths in Mexico due to drug wars, 164,000 in 7-year period of time, 07 to 2014, 164,000. 2016, he reports 20,000. There's another report out there that's at 28,000. And 2011, he claims is the peak at 27,000 drug war deaths in Mexico. I recall a report from 2 or 3 weeks ago that 28,000 drug war deaths in Mexico is second only to the 50,000 deaths in the civil war in Syria. Or to draw that into a comparison, from 2007 till 2014, 164,000 Mexican drug war deaths in Mexico, compared to the total deaths in the combat in Afghanistan and Iraq for that same period of time, 103,000. So somebody killed those people. They were murderers that killed those people. And among them were other types of lawbreakers, including rapists, and certainly they were drug dealers or they were involved in the drug trade because that's the war that they were fighting. Some of them didn't tell the truth as well. And so I think the discussion that's being missed here is the challenge that would be if the Gutierrez Amendment should go on this bill, the challenge that would be there for U.S. law enforcement officials of all levels. How do you identify an American citizen? If you guess wrong, you're liable under this bill, but yet responsible law enforcement requires that they profile and draw a conclusion. In fact, it says in 8 U.S.C. 1225, if I'd read right here from the code, if it is not clearly and beyond a doubt entitled, if the alien is not clearly and beyond a doubt entitled to be admitted, the alien shall be detained for a proceeding under Section 1229A of this title. That's requiring to put them in removal proceedings. That's the law that directs our law enforcement officers, and we want a level of responsibility that's there. But the gentleman from Illinois objects to profiling. And yet I will say it's an essential component of law enforcement. There is no law against profiling. We couldn't conduct responsible, legitimate, good judgment law enforcement without drawing conclusions or at least indications by profiling. It's a legitimate and appropriate thing to do, and the gentleman from Illinois has made that point himself by taking credit for profiling a Muslim couple on an airplane. We all do these things because it's part of our society, it's part of good judgment. We're called to decency and good judgment. Our law enforcement are called to decency and good judgment, and the alternative is if we go with the Gutierrez Amendment, we're going to be switched back around, and we're going to have to ask the American people, prove your citizenship to us. And I don't want to go down that route. So I rise in opposition to this amendment. I urge that it be defeated, and I yield back the balance of my time.
Question occurs on the amendment offered by the gentleman from Illinois. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment's not agreed to.
Roll call.
Roll call. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shavit? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Mr.
Aye.
Conyers? Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Gentleman from Ohio.
Mr. Shabbat votes no.
Has every member voted who wishes to vote? Clerk will report. The gentleman, clerk will suspend. The gentleman from California.
Mr. Issa votes no.
The gentleman from Utah.
Mr. Chaffetz votes no.
The gentlewoman from Texas.
Ms. Jackson Lee votes aye.
Mr. Chairman, may I ask how I'm recorded?
Gentleman is recorded as an aye. Clerk will report. Gentleman is recorded as an aye.
Mr. Chairman,
Gentleman is recorded as an aye.
Mr. Chairman, how am I recorded?
Gentleman is recorded as an aye.
Chairman, how am I recorded?
Gentlewoman is recorded as an aye.
Mr. Chairman, 11 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there further amendments to
Mr.
H.R.
Chair-
2431?
Oh,
The clerk will report the amendment of the gentleman from Illinois.
Amendment to H.R. 2431 offered by Mr. Gutierrez of Illinois. Page 147, line 4, insert after the period at the end of the following. A deportation officer may not be equipped with a weapon
Without objection, the
under...
amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This legislation authorizes ICE agents to carry military-style assault weapons. And I'd like to make sure that the people to whom we are giving military-grade weapons are trained and cleared to use them, and that such weapons don't fall in the wrong hands. Therefore, my amendment requires that officers hired by ICE go through the same rigorous hiring routine, the screenings, and the background checks that we put in place for special agents at the FBI. The Special Agent Selection System has a proven record of weeding out bad apples and making sure that the people in whom we place our highest trust as sworn officers of the law are worthy of that trust. Quoting from the FBI's employment website, it says, quote, "The Special Agent Selection System is designed to identify the best candidates. Please keep in mind that the process typically takes at least 1 year or longer to complete." It goes on to outline the education, achievement, and physical fitness tests that an agent candidate is required to have completed as part of the application. There is a 3-hour test of cognition, behavior, and logical reasoning, and an in-person meet and greet that is phase 1. If you make it to phase 2, the website says there is more physical fitness training required and a thorough background check. Quote, "The background investigation for special agent includes a medical examination, drug testing, and a polygraph test." So my amendment simply says that we should use the same high-quality intensive screening process for ICE agents who will now be armed with the same military-style weapons, at least as vigorous as the FBI. If you're going to give them the same guns, they should go through the same vigorous testing. There are those on the other side of the aisle who count boots on the ground as the only metric of enforcement, yet we have seen what happens when standards are lowered. I do not know all the circumstances surrounding the shooting of a 53-year-old man in my district in March, but what I do know is that an ICE special agent shot someone, not an immigrant, not someone they were looking for, in Chicago after they raided the home. We have been trying to get more information on this incident for the family from ICE, both regionally and nationally. And so far, we haven't been able to get anyone to tell us what happened when those ICE agents arrived at that home at 6 in the morning. But I suspect, given how quickly things are changing and how little control, oversight, and consistency we're seeing from Washington on any number of issues, that people are getting shot by ICE in neighborhoods in American citizens is more likely to increase than decrease. And now we're giving them bigger, heavier weapons. Remember, ICE and Homeland Security constitute the largest police force we have, bigger than the DEA, the FBI combined, and the Secret Service. They are the biggest police force that we have. So I think the need for a high-quality force of ICE special agents is at least as important as the quality that we demand from the FBI and ICE as a component. To establish a high-quality workforce and prevent corruption and policing abuses, DHS must prioritize careful vetting and training standards, quality over quantity. Quantity makes for a good press release, but lowering standards can lead to tragedy. So in the end, quality makes for good law enforcement. If we're going to give them these new assault weapons, they've never had them before. Now the people that get them are FBI agents. Shouldn't they have the same standards of training and background? And shouldn't they make sure they all get a polygraph test? We're going to give these people, we've already established that they're going to come in contact. My colleague and friend from Iowa said it didn't matter. Yeah, American citizens are going to be, but there's no reason to protect them. That's why my last amendment. So we know they're going to come in contact with Americans. They have come in contact with Americans. We should make sure that we give them the training. This doesn't stop anybody from hiring them. It doesn't stop the bill. It simply improves the quality of Americans that we're going to put to be exchanging with American citizens. I would think we all want to protect the American people and give them the best trained, most highly qualified ICE agents that we can. If we're going to give them these guns, we should give them more training. Thank you, Mr. Chairman.
Gentleman returns his time. For what purpose does the gentleman from Idaho seek the floor?
Mr. Chairman, I oppose the amendment.
Gentleman's recognized for 5 minutes.
Again, I'll be brief. Deportation officers receive pretty extensive training at the Federal Law Enforcement Training Center, including weapons training, and they will continue to receive that training. And these officers are sworn to uphold the law, and they're already subject to stringent requirements, including background investigations and others. And in fact, our bill, in Section 506, specifically says that the Secretary will determine the rate at which the additional officers will be added with due regard to filling the positions and without making any compromises in the selection or the training of the additional officers, which means that the standards will not be lowered. In fact, they should remain as stringent as always. And with that, I yield back.
The question is on the amendment. What purpose does the gentlelady from California seek?
I to strike the last word.
Gentlelady is recognized for 5 minutes.
I think this is a very modest amendment that really, I can't believe that we can't come together on a bipartisan basis to do this. This isn't just about immigrants, this is about everybody. And when you talk about interior enforcement of the immigration laws, what you're talking about are ICE agents going to courthouses, to places of employment, to people's homes early in the morning, really going into neighborhoods all over America. If we're going to give them assault weapons, I think the minimum we should want is that they have training that is equivalent to what we have our FBI agents trained for. Recently, the Secretary of Homeland Security had a meeting with me and a few other people, and he made this assertion that the ICE agents were as trained as the FBI. I think Mr. Cicilline was there at the same meeting. That, in fact, is not the case. For example, the ICE agents are not hired with a polygraph. So I think that's something that's severely missing overall in the recruitment. But at least you want the protection if you're going to send armed agents into neighborhoods where they could end up shooting people. You want them to be trained. And that we wouldn't want to do that to protect American citizens who are in those neighborhoods, I think is stunning. It's simply stunning that we wouldn't want to do this. So I don't understand the objection, even though it's reflexive and we have party line votes on most of these amendments. I just think this is modest. This doesn't say don't give them assault weapons. It says make sure they're trained to use the assault weapons. Let's at least have them be the standards. And I understand that the ICE training is 14 weeks of training. That is far, far less than the training that the FBI agents receive. And so I think this is a very sound amendment and really one we ought to accept.
Will the gentlelady yield?
I would be happy to yield.
Thank you. I simply say I cannot understand why the majority or why Mr. Labrador would not want the best possible training. So here's the FBI training at this level, and here's ICE training. All we are saying, give them the assault weapons. This doesn't stop them from getting their assault weapons. It simply says we want them to be trained like every other law enforcement officer in the United States that gets at the federal level, that gets an assault weapon. You want an assault weapon? You got to be an FBI agent. We're changing the rules right here. And why wouldn't you want an ICE agent to get a polygraph? It would seem to me that you would want to use all the tools that you have at your disposal to get at the truthful nature of the applicant. Why wouldn't we want them to have one? I can't understand. FBI agents are required. So why aren't we raising the standards? Raising the standards for being employed as an ICE agent. I can't understand. We should be here protecting the American people. Again, this isn't an immigration amendment. This is an American amendment that's going to protect Americans and says we want people working in America, American citizens that are trained to do the job of law enforcement. And I give the gentlelady back her time.
Reclaiming my time, I would note that actually the amendment doesn't raise the employment standards for all the ICE agents, only for those that are going to be handed these weapons. I actually think, although I don't think it's germane necessarily to the bill, maybe it is, we'll look at it, that upgrading the standards for employment overall would be a good thing, at least to have a polygraph, to have more background checks, so we've had instances in immigration where you have agents who are corrupt. I'm not saying it's most agents, I'm sure it is not, but you certainly want to prevent that from happening. You don't want agents that are on the take. You don't want agents that are of questionable morality, and one way to do that is to make sure you've got the highest employment standards. But this is more modest than that. It's just train the guys that you arm. It's stunning to me that we would not want to do that, and I yield back the balance of my time.
The lady returns her time. The question is on the amendment, the Gutierrez amendment. All those in favor signify by saying aye.
Aye.
All those opposed, nay. No.
Come on.
The noes appear to have it. The noes do have
I
it.
ask for a recorded vote.
Gentleman's requested a recorded vote. The clerk shall call the roll.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
Anyone wish to cast or change their vote? The gentleman from Florida, Mr. DeSantis.
Mr. DeSantis
Gentleman
votes
from
no.
Texas, Mr. Ratcliffe.
Mr. Ratcliffe votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
The gentleman from California, Mr. Issa.
Mr.
no.
Issa votes no.
Anyone else wish to cast or change their vote?
Mr. Chairman, I'm wondering how I am recorded. Could the
As
clerk
an aye.
please tell me?
You're recorded as an aye.
Mr. Chairman, Mrs. Lofgren's question has caused me to wonder the same. How am I recorded?
I'm stumped again, but I'm going to guess an aye.
Thank you.
Mr. Johnson has arrived.
Gentleman from New York.
fails me. How am I recorded?
It's the first time, and you're recorded as an aye.
Could you check that with the clerk, please, because I'm not sure.
Well, I would check with the clerk. How is Mr. Nadler recorded?
Aye.
Thank you very
As
much
an
for
aye.
refreshing my memory.
Mr. Johnson from Georgia
Mr. Johnson votes aye.
votes aye. Anyone else wish to cast or change your vote? If not, the clerk will report. The clerk will report. I said that.
Mr. Chairman, 11 members voted aye, 15 members voted no.
11 members voted aye, 15 members voted no. The Gutierrez amendment has failed. Chair would recognize the gentleman from Rhode Island.
Mr. Chairman, I have an amendment at the desk.
Gentleman has an amendment at the desk. Clerk will distribute. Gentleman's recognized for 5 minutes to discuss his amendment.
Thank you, Mr. Chairman. My amendment would strike Section 608 of H.R. 2431, providing that if the Secretary of Homeland Security makes a submission for temporary protection status designation, which the President does not sign into law within 90 days, the designation shall be terminated. This amendment would also remove a provision providing that holders of temporary protection status may not be admitted for the purpose of adjusting their status. Temporary protection status, or TPS, is a temporary and renewable immigration status that allows for employment authorization and relief from deportation for immigrants from countries that are experiencing temporary environmental insecurity, armed conflict, or extraordinary conditions. This form of humanitarian relief upholds America's traditional role as a safe haven for those fleeing repression, persecution, and harm. For example, the country of Liberia suffered through a 14-year civil war that only ended in 2003. As the conflict persisted, roughly 250,000 people were killed and the infrastructure of the country fell into ruins. In the early 1990s, thousands of Liberians fleeing this brutal civil war sought refuge in the United States and were allowed to live here legally under temporary protected status, many of whom now live in my district. And more recently, Liberia, as well as Guinea and Sierra Leone, are rebuilding their countries after suffering through massive outbreaks of Ebola lasting from 2014 through 2016. Temporary protected status for Liberians has extended much-needed humanitarian relief, protecting them from forced repatriation to a country with a greatly weakened medical infrastructure and a still lingering deadly disease. More than that, in many cases, refugees protected by TPS raise children in America and become integral members of their local communities, contributing to the local economy and culture. Any provisions that undermine TPS would truly be short-sighted, as we would lose the contributions these immigrants make every day to our country. For example, ending TPS for people from just 3 countries, Honduras, Haiti, and El Salvador, would cost taxpayers $3.1 billion and will result in a $6.9 billion reduction to Social Security and Medicare contributions over a decade. I'm extremely concerned that this legislation's provision on TPS is an extension of the current administration's cruel and draconian policies toward the most vulnerable immigrants. In his short time in office, President Trump has tried to limit the admission of refugees into the United States and entirely halt the admission of Syrian refugees. In doing so, he knowingly sought to turn away women and children fleeing unspeakable brutality at the hands of President Bashar al-Assad and individuals that have been displaced by a perpetual violent conflict. Although this inhumane and unconstitutional executive order has been struck down in court time after time, the Trump administration is still unwilling to allow Syrian refugees into the United States. At the same time the administration was defending the refugee ban, the Secretary of the Department of Homeland Security proposed to separate families at the southern border in order to deter asylum seekers migrating from El Salvador, Honduras, and Guatemala. Well-known threats of gang violence and economic desperation in this region have driven entire families to seek safety in other countries, and mainly the United States. Policies which undermine protections for vulnerable people seeking safe havens, such as those in the bill before us, and those set forth by the Trump administration, are a profound betrayal of the values that define us as a nation. And I urge my colleagues to adopt this amendment to ensure that we preserve protections for holders of temporary protected status and recommit to our proud and long history of humanitarian protection. And with that, I yield back the balance.
Gentleman returns his time. For what purpose does the gentleman from Idaho seek recognition?
To oppose the amendment.
The gentleman is recognized for 5 minutes.
Congress has granted the Secretary of Homeland Security the authority to grant temporary refuge to aliens, usually illegal aliens, from particular countries under temporary protected status. If the Secretary finds that there is an ongoing armed conflict and the return of nationals would pose a serious threat to their security, if there has been a natural disaster resulting in a substantial but temporary disruption of living conditions, or if there exists extraordinary and temporary conditions that prevent aliens from returning in safety, he can grant TPS status to a country's nationals for as long as 18 months. The Secretary can later extend the designation for additional periods of as long as 18 months. Congress intended TPS to provide temporary refuge during temporary periods of crisis in a country. Unfortunately, it has become all too apparent that DHS has utilized TPS as a de facto amnesty for many aliens. For instance, TPS was granted to Honduras and Nicaragua in 1998 following Hurricane Mitch. The administration has extended these designations numerous times, the latest until 2018, long after any temporary dislocations caused by the hurricane have ended. Let me cite the example of Nicaragua. DHS granted its latest extension because Hurricane Mitch and subsequent environmental disasters have substantially disrupted living conditions in Nicaragua. Nicaragua remains unable temporarily to handle adequately the return of its nationals. The INA provides that an initial designation of TPS can only be extended if the conditions for such designation continue to be met. The conditions refer to the conditions that led to the original designation. This latest extension was clearly an illegitimate exercise of DHS's authority. First, DHS did not extend TPS for Nicaragua because the original conditions continued to be met. DHS stated that TPS was extended because of Hurricane Mitch and subsequent environmental disasters. There's no substantial basis for extending a country's designation of TPS because of events not the basis for the initial designation. The only legitimate basis is that the conditions for the original designation continue to be met. Second, TPS is based on a nation being able to adequately handle the return of its nationals. Congress did not create TPS as a remedy for nations who are permanently unable to handle the return of their nationals for economic, political, cultural, or other reasons. It is difficult to make the case that when TPS is extended 2 decades after the landfall of a hurricane, the beneficiary nation can still be said to be unable to handle the return of its nationals. Third, even if DHS had found that the disruption of living conditions in Nicaragua caused by Hurricane Mitch still existed, it is not plausible that Nicaragua is unable temporarily to handle adequately the return to the state of its nationals. There are about 2,500 Nicaraguans benefiting from TPS. This represents a minuscule percentage of Nicaragua's population of almost 6 million people. For Nicaragua not to be able to handle the return of persons representing such a small percentage of its population 18 years after a hurricane seems pretty dubious. Additionally, this number is dwarfed by the 1.3 million international tourists who visited Nicaragua in 2014. It seems inconceivable that Nicaragua could handle over 1 million tourists in a year while being unable to handle the return of a few thousand persons following the termination of TPS. Therefore, Section 608 provides that if DHS believes an extension of an original TPS designation is appropriate, it may make such a recommendation to Congress. Congress can then pass legislation implementing the recommendation. If 90 days after a recommendation is submitted, the President has not signed implementing legislation into law, then the designation will and should expire. Given the irresponsible manner in which DHS has administered TPS over many years, it is time for us to engage in some supervision. I should note that Section 608 only affects extensions of future TPS designations. It does not apply to extensions of designations made by DHS or INS before the date of enactment. And I yield back.
Gentleman returns his time. Chair, for what purpose does the gentlelady from California seek the floor?
To strike the last word.
Gentlelady is recognized for 5 minutes.
I think this is a really important amendment that Mr. Cicilline has offered. The way 608 is crafted, it would really end TPS as a tool in the toolbox of the United States. I can't think of very many immigration measures that have been signed into law by the president in 90 days. We had a bipartisan bill sent over from the Senate that never even got a vote in the House. We don't do immigration laws in this Congress. So to provide that the TPS needs to be signed into law by 90 days or the status expires, basically just says we're not going to have TPS. Now, we can argue the humanitarian impact of this, and I can. I mean, for example, among the countries, there's 13 countries. There are 300,000 people who have, over the years, received this TPS status, which allows them to legally stay in the U.S., to get work authorization, and to work and become taxpayers. These individuals are from El Salvador, Guinea, Haiti, Honduras, Liberia, Nepal, Nicaragua, Sierra Leone, Somalia, Sudan, South Sudan, Syria, and Yemen. They all have different stories, different reasons why that occurred, but let's just talk about Haiti for a minute. Haiti, we had 46,000 Haitians on TPS status after that monstrous earthquake, which Haiti has still not been rebuilt. We now have a cholera outbreak in Haiti, and there's really no indication whatsoever that Haiti could accommodate the rapid influx of 46,000 Haitians. There are 9,000 Nepalese who are in TPS status after a monstrous earthquake in Nepal that killed 8,000 of its citizens. That earthquake destroyed more than 500,000 homes. The country is not recovered yet. To send 9,000 Nepalese home right away, they couldn't handle that. But let's talk about the economic implications for the United States. Mass deportation of the 300,000 TPS recipients would have a substantial adverse impact. Let's just take a look at the Salvadorans, the Hondurans, and the Haitians. The analysis is that this would trigger a $45 billion decline in GDP over the next 10 years. It would reduce $6.9 billion of payments into Social Security and Medicare. It would have a turnover cost of laid-off employees of $1 billion, and it would cost $3.1 billion to the taxpayers to deport them. The economies of Texas, Florida, Virginia would be particularly hard hit. And for what reason? I think that this is heartless, economically unwise, and not in keeping with the American tradition. I strongly support Mr. Cicilline's amendment.
The gentlelady returns her time, and I would Chair would recognize himself to oppose the amendment, and I will keep it very brief. I wanted to make the point that the underlying bill grandfathers in all of the circumstances that have been discussed by the gentlelady from California on temporary protected status, and it only addresses any circumstances going forward. And so those circumstances going forward would be under the full knowledge that Congress would have to approve the extensions of the temporary protected status. And so I'm oppose the amendment, and I would urge that it be defeated. Seeing there is no further debate coming forward on the Cicilline amendment, the committee will stand in recess for the day. The committee will resume consideration of this bill tomorrow morning at 10. We're not going to vote on the amendment. So the committee will stand in recess. We'll resume consideration of this bill tomorrow morning, 10 a.m.
Thank you. Thank you very much.